More correct?
I have, yeah.
Okay,
It's
all right.
better.
Okay, so. See the channel where it is? turn.
Supreme Court First Department. Hear ye, hear ye. All persons having business with the Appellate Division draw near. Give your attendance and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, October 17. So you know the spiel. Only request the time that you actually need, not the time that you would have in a perfect world, because as we all are fully aware, this is not a perfect world. So, People v. Savion Robinson. Excellent, submitted. I didn't mean excellent, I mean submitted. 1995 Cam versus Westside Advisors.
Yeah, I have 5 and 3 for the appellant, please.
535. Matter of Melanie J. Submitted. Rotobomb versus Bornstein and Scheinbaum.
The appellate, Your Honor, 5 minutes.
Who are you?
For the respondent, Your Honor, 5 minutes.
5-5. There's no cross appeal on it? Okay, 5-5. Flores versus Exotic Design and Wire.
On behalf of the appellants, 5 for argument and 3 for reply, Your Honor. For the respondent, 5 minutes.
525. People v. Dennis Logo.
Good afternoon, Your Honor. Appellants have 5 and 2, please.
For the respondent, 5 minutes.
525. Strawbag Spa versus Credit Agricole. Submitted. SJW versus Farther Realty. I'm sorry. Oh, who's that?
Sorry, Your Honor. Adam Laurie for the appellant intervener. Also on my vote.
I'm sorry. On People v. Dennis, Strawberg Spa?
Yes, Your Honor.
Okay, now, who are you?
Appellant intervener. Also on my vote.
Okay, and,
7 and 3, Your Honor.
okay. And who are you? 10-3. Okay, 525. SIWA versus Farther Realty.
Appellant Father Realty, 7 and 2, please.
For the respondent, 7, please.
For respondent, appellant, 7.
6 and 2, 6 and 6. Equitable Financial versus Shanti.
Good afternoon, Your Honor. The appellant requests 5 and 3, please. Good afternoon, Your Honor. 5 minutes for the respondent.
535. People versus Michael Sjwa. Submitted. Kellet versus Light Tower Fiber.
Good afternoon again, Your Honor. Appellant requests 5 and 3, please.
Respondent, ECS Verizon, 5, please.
Respondent Hellman, unless this court has questions for Hellman, we will submit.
That's a submission. So, I'm sorry, that's, I'm sorry, Appellant, how many did you request?
5 and 3, Your Honor.
5 and 3, 5 and a submission. That's right. Did I miss one? No, okay, thank you. ARC 265 Dill versus Archdiocese of New York. Submitted. Dowlar versus American Arbitration. Submitted. Wilson versus the City of New York.
Plaintiff respondent, Wilson, 4 and 2, please.
What's the 2 for? There's nobody here. Did you wish to submit, or did you still want to argue against yourself?
Oh, I'm sorry, I thought that at least the city would be here. No, then we can submit, Your Honor.
Submitted.
Unless there's questions.
I think we're good. Thank you. People versus Bernard Fuller. Matter is submitted. Board of Managers versus Hung.
Appellant, 5-3, Your Honor. Respondent, 5, Your Honor.
535. MA and Infant versus Spring, submitted. Decatur, 1147 versus Anson Street, submitted. First case for argument, People v. Savion Robinson. Was that submitted? I'm so sorry, submitted. Cam, 1995 Cam versus Westside Advisors. I was wondering why there was nobody coming up to the podium. I was like, what's going on?
May it please the court, my name is Tom Lambert. I would like to make the point that the guarantor is not liable for post-vacatur rent.
Why would the guarantor not be liable under the guarantee?
Because the guarantee itself, which is, I believe, fully and most legibly set forth at page 8 of our main brief, is a limited guarantee. It says that the guarantor is liable to the date when the tenant completely vacates and surrenders the demised premises in a certain way. The tenant has to provide notice, which was done. The surrender has to be free and clear of subtenancies and occupants, which is so, all acknowledged. And the surrender has to be made pursuant to the terms of the lease. Now,
Counsel, I'm so glad you brought that up. Over
Yes.
here, Justice Kennedy, thank
Yes,
you.
thank
I'm so glad you brought that up about the lease.
Yes.
Because written acceptance of surrender is required under paragraph 25 of the lease. So my question is, was that done, the written acceptance of the surrender?
Judge, respectfully, I disagree with that. In other words, paragraph 25 does not at all talk about the way in which surrender must be made. Paragraph 25 is set forth in full at page 3 of our brief, and the parties very well understood the difference between surrender and acceptance of surrender.
Why don't we stay on paragraph 25?
Yes.
Because, and I'm going to paraphrase, but no act or thing done by owner during the term shall be deemed an acceptance of a surrender of said premises, and no agreement to accept such surrender shall be valid unless in writing signed by owner.
Yes, and the guarantor subscribes to that paragraph completely.
Okay?
In other words, the guarantor is not arguing that the surrender was accepted, not trying to pin that on the landlord. He didn't accept any surrender by the tenant, not by doing what he did. In other words, that's the point. But there was no duty on the part of the guarantor to see to it that the surrender was accepted in order to limit the liability under his guarantee. His duty was only to do the surrender in the way in which the lease and the guarantee says that he must do it.
But
Is there a
counsel,
paragraph?
Counsel, aren't you contradicting yourself?
No.
So if you look at paragraph 9 of the second modification of the guarantee, it does say that the tenant has to have vacated and surrendered pursuant to the terms of the lease.
Yes.
And as my colleague has noted, the terms of the lease include language that there's no surrender unless there's acceptance by way of a writing.
That's not correct, Judge.
Well, where does the writing say something different?
Well, first of all, the first point is that the writing does not say what you suggest and what the landlord is suggesting.
Well,
It
Let's
wasn't a
look
sug-
at that
It wasn't a
paragraph.
suggestion, it was what's
Reading
stated.
verbatim.
It was reading what's in paragraph 9 of the second modification.
It says no act or thing, as Justice Kennedy read it, no act or thing.
That's 25, now we're on 9. What my colleague just read to you was paragraph 9.
Yes. But that doesn't talk about the methodology of surrendering.
It actually does, to the extent that it says pursuant to the terms of the lease.
Yes.
So
let's look at
pursuant to
the
the terms
lease.
of the lease. No, but I did read to you from paragraph 25.
Yes.
The problem, counsel, is that you're arguing against the written word.
No, Judge, that is not, I'm going with the written word exactly. Now, let's just look at the written
The
word.
written word says at paragraph 25, no agreement to accept such surrender shall be valid unless in writing signed by the owner.
Yes, but we're not claiming acceptance. That's the point. We're not claiming acceptance.
Point is that we're talking about paragraph 9 in the second modification to the
that's
guarantee that says pursuant to the terms of the lease.
Lease.
This is a circular argument,
wait.
counsel, at this point.
I'll come right out of the circle. Is there a place in the lease where it describes the methodology of surrendering? Yes, there is. It's not paragraph 25. It's paragraph 22, which is set forth in full and legibly on page 2 of our brief. Paragraph 22 describes the way in which surrender is supposed to be done under the lease. It says it's got to be broom clean, in good order and condition, ordinary wear, and etc. All of those conditions describing the methodology of surrender in paragraph 22 of the lease were fully complied with by the tenant, and the landlord admits that. The landlord is throwing in paragraph 25 and 9 to boot, which has to do with when is it that the landlord shall be deemed to have accepted a surrender. We're not claiming that the landlord accepted any surrender. No, not at all. It wasn't the duty of, if the landlord was required to have accepted a surrender in order for the guarantor to be off the hook, there was no need for any of this.
So, counsel, you're arguing that the lease talks about the methodology.
Yes.
And that the methodology was not in place. Is that what you're saying?
Methodology was followed to the letter.
The methodology was followed to the letter.
Yes.
Okay. However, it also states specifically that the surrender has to be in writing.
No, it doesn't.
And
No,
it
it
says,
doesn't, Judge. No.
No agreement to accept shall surrender.
No
No agreement to accept such-
no agreement
such
to accept
surrender,
the surrender unless in writing. We're not claiming there was any acceptance. We don't need any acceptance. This language of no waiver. Look, this is the no waiver clause. It says we won't be deemed to have consented to a default just because we didn't complain about it early. We're not going to be stuck. Or you can't pin on us, the landlord, an acceptance of a surrender, which, as we know, cancels the lease, unless we've signed a writing. We're not looking to pin on the landlord an acceptance of any surrender. Not at all. There may be, as far as this argument on the guarantor goes, there may have been no acceptance of any surrender at all. The tenant may still, as far as the guarantee is concerned, may still be continuing to be liable for the rest of the term of the lease, whether he's there or not.
And how would the guarantor now become liable? Under what
The
circumstances?
guarantor is off. The guarantor is off the hook because he did follow all of the limitation conditions in the guarantee, which says if you do this, you're off the hook. Look, it's a good guy clause. We all know that. And the landlord acknowledges that it's a limited guarantee. Well, how is it limited? It's limited that if he surrenders in this way, according to this methodology, he's off the hook once the tenant vacates.
Okay, we'll hear from your adversary.
Thank you, Judge.
Your Honors, may it please the court. It's undisputed here that there was no,
Counsel, who are you?
Nicole Meyer from Board Goldstein for the respondent. It's undisputed that there was no written acceptance of surrender. It's also undisputed that the plain terms of the guarantee require that surrender be done pursuant to the terms of the lease. Can direct your attention to cases Empire.
What about paragraph 22 that your colleague has pointed to?
Yes, so paragraph 22, that's entitled end of term. Basically, that provides the tenant's obligations with respect to the condition of the premises when the lease has either expired or terminated. It's inapplicable here where the tenant has vacated mid-lease and without written consent from the landlord to accept surrender. So it has nothing to do with whether or not there is a proper surrender. It just sets forth the obligations of landlord with respect to the premises, that it's broom clean, that there's no other tenants and occupants at the end of the lease term or where there was a termination of the lease. There has been no termination of the lease. The lease did not expire by its own terms. So we are governed by paragraph 25. Both the cases Empire LLC versus Sharapov involves a nearly identical both guarantee, which required surrender as otherwise required by the lease. It also involves a paragraph 25 that said acceptance of a surrender would not be effective unless it is in writing and signed by the landlord. That's exactly what we have here. That was decided by this court in 2021, and it governs the situation in this case. 274 Madison Co. LLC versus True Legacy Partners, the same exact thing. It includes a guarantee that had a provision that said that surrender needed to be done as required by the lease. You turn to paragraph 25 of the lease, and it says no surrender shall be, no acceptance of surrender shall be inferred except with a writing signed by the landlord. That has not happened here. It's undisputed, and so guarantor's liability continues because he has not fulfilled each and every one of the conditional limitations within the good guy guarantee.
We talk about post-surrender lease, post-vacatur lease ideals, sorry, post-vacatur rent.
Yes.
Forgive me. So was the owner required to make reasonable efforts to relet the premises in order to be entitled to those monies?
No, that is not the case. There's nothing in common law that requires a landlord to make obligations to relet unless there's something specific in the lease that requires it, and there's nothing in paragraph 18 that requires a landlord to make reasonable efforts to relet, and the premises was not relet. By the time the re-argument motion was decided, the lease had expired by its own terms. There was no reletting, so the court properly awarded lease damages through the end of the lease term. If there's nothing else, I'll rest on the papers.
Thank you.
Thanks.
You know, my colleague is correct that paragraph 22 of the lease, which describes surrender, is entitled end of term. It was designed to talk about the way in which the term would be surrendered at the end of the term, not under the guarantee. The guarantee, of course, was done later.
So, counsel, let's just back up for 1 second. The guarantee states that the guarantor's liability continues until the tenant shall have completely vacated and surrendered the premises to owner pursuant to the terms of the lease.
Right.
One of the terms of the lease is paragraph 25,
Yes.
which requires a written acceptance. So are you arguing, it does, that's
No,
what
it doesn't.
25 says.
No, it doesn't.
So are you arguing that 25 is not,
It doesn't
should
say
not
that.
should not be considered?
Judge, I'm terribly sorry. I think you must consider paragraph 25. I think we should look at it carefully now.
Okay, so then we
It
look
doesn't say that surrender has to be accepted. Of course not. I like the fact, I point out the fact that paragraph 25 shows that the parties, when they made this lease, understood very well the difference between surrender on the one hand and acceptance of surrender on the other hand.
I beg to differ, counsel. I mean, the writing is really clear. You're saying that there's no relationship between acceptance and surrender, that surrender is adequate. I mean,
No.
I guess we've read this a few times already, but it does say,
Yes.
no act or thing done by owner or owner's agents during the term hereby demised shall be deemed an acceptance of a surrender.
Right, but that doesn't, we're not claiming any acceptance of a surrender here. We don't need an acceptance of a surrender here.
I think,
They understood, they used those words, acceptance and surrender, twice in this sentence. They said, nothing shall be deemed an acceptance of a surrender, and no agreement to accept such a surrender. So according to the parties here in this sentence, there are two different ideas here. There's acceptance and there's surrender. And what this sentence says is, look, don't claim, don't try to pin on us an acceptance of a surrender unless we sign a writing. They understood there could be a surrender. The tenant is free to surrender anytime. A tenant can get out, deliver the keys, tender possession back to the landlord.
Counsel, but, you know, trying to understand this in some sort of, to something commercially reasonable about what you're suggesting, I mean, the idea of the guarantee is the guarantee was going to guarantee the rent so long as it's due. You seem to contemplate with the construction you put upon this is that the guarantor goes out of the picture at a point where, like, there's really no question that the rent remains owing under the lease.
Exactly. Exactly. And that's what's called a good.
But that's not really, you know, the idea of the guarantee was if the rent is due, the guarantee is guaranteeing the rent.
Yeah, that's
But
why.
you're suggesting something which
Not every
varies from
guarantee.
that.
That's true, Judge, what you say, but that's not true of every guarantee.
So what
It's
was,
not- You can negotiate something different.
Yes, which
But
was
if
what we
that's-
did. And
it's a
look, this is done all,
wait, Counsel, just,
twisted way to get to that point.
Judge, this is common. This is a good guy guarantee. This isn't a unlimited guarantee. This is what we all know and have seen so many times is a good guy guarantee. Meaning, if the tenant vacates, gets out lock, stock, and barrel, leaves the premises vacant, free, and clear for the landlord to do whatever it wants with, rent, re-rent, or do whatever, then the guarantor is off the hook, not the tenant. And I'm not suggesting here in this argument about the guarantee that the tenant is left off the hook, that the landlord has accepted a surrender and that there's been a cancellation of the lease. I'm not suggesting that on this guarantee point. I'm only suggesting that the guarantor is off the hook, not that the tenant is off the hook.
no, we understand that because you represent the guarantor.
Well, that's not the reason, but Judge,
No, but I understand,
that's
but we
my
have,
motivation.
thank you so much. We appreciate it.
Thank you, Judge. Thank you, Your Honor. Thank you very much.
Rotobomb versus Bornstein and Scheinbaum.
Good afternoon, Your Honors. I'm Richard Bonfilio. I represent the appellant. I believe the gravamen of this appeal involves the meeting of two maxims. The first one is that you don't get a second chance to form a good first impression. And the second one is that lawyers owe a duty of zealous representation to their clients within the bounds of the law. These two maxims met together on the eve of the divorce trial underlying the malpractice action that we're here on now. On the eve of trial, the then defendant in the matrimonial proceeding was stricken with a case of eczema. You saw her doctor. She got a doctor's note indicating that she shouldn't attend trial. Her counsel requested a continuance. It was granted for a single day. Unfortunately, on the second day, the special referee appointed to hear and report on the matter decided that was the furthest limit he would go, and then commenced the trial. Testimony was taken for a total of 7 days before the...
But your case as to the malpractice comes down to, does it not, to the valuation of the Agricole business?
Not really. It's the allocation.
The allocation of the Agricole business,
I would say...
It's your position that the plaintiff did not get enough of a share of that business.
Correct.
But that issue has come here otherwise, has it not, before the appellate division, and we upheld the allocation that was made.
You did, Your Honor, but you did so.
So doesn't that upholding of the allocation fatally undermine your legal malpractice case?
I don't
Because
believe
you,
so,
in
Your Honor.
effect, said there's nothing wrong in that allocation. So how can you say that there's been legal malpractice in the proceedings which led to that allocation?
I would say it thusly. There were two things that went wrong. One, the referee formed a negative impression of the appellant by her non-attendance during the time that she was recuperating. And that's exactly the point in time.
And how do we know that?
Excuse me?
What is that based upon, that there was a negative impression formed? And how does that color or go to the valuation which we had previously upheld?
Well, it was upheld, Your Honor, because none of what the appellant sought to have done on her behalf during the divorce trial got into the record. The whole issue of whether a continuance should have been granted or not
Counsel,
wasn't preserved for appeal.
Is this an end run around our prior decision without actually seeking re-argument in that matter?
I don't believe it's an end run, Your Honor. I'll tell you why. What I'm pointing to was never heard by this court in the appeal in the divorce action because it was never preserved for appeal. Not the matter of the continuance, not the matter of the failure to call witnesses who could have testified on her behalf and perhaps shifted the scale from 10% of, not for anything, it was a $28 million marital estate. This was not chump change that was being divided. This was serious assets. The appellant had a right to confront the witnesses against her. She had the right to produce testimony that either rebutted or enhanced the way she looked to the referee.
And so, counsel, are you referring to the previous decision? What was that, Cotton versus?
Yes.
So, did you appeal that decision?
The appeal of the Appellate Division First Department determination?
Yeah, that's us.
No.
Did you appeal that?
No.
Because but isn't it the same argument that there should have been additional information imparted which would have led to the decision as to the valuation?
I wasn't part of that appeal, Your Honor, but my sense as a trial and an appellate attorney is they couldn't appeal it because there was no preservation of the issue on appeal. In order to create
So how is it now that you can argue that we should consider, or that that Supreme Court should have considered that information? That's what my colleague is asking you. Aren't you like taking an end run around this, trying to, maneuver a way to argue that our previous decision, our previous determination?
But I don't think you had an opportunity to look at that issue when you considered it in the divorce appeal, because the issue was never preserved for appeal. Nothing was marked in evidence. The doctor's note, the photographs, they didn't then take the referee's determination and go to the trial judge and ask for a continuance. None of that happened, and that's how the hole got into the dike to begin with.
So that's your argument as to how they committed legal malpractice.
That's the way it started, and the rest is failing to call witnesses.
And so how do we know that those actions or inactions would have led to a different result in terms of the valuation? Have you presented anything which would lead us to that conclusion?
We never got to that stage because the malpractice action was dismissed summarily. So there was never any fact-finding as to whether or not, no offer of proof.
But don't you have to present that now on appeal? Don't you?
I can't produce to you that which has never yet been put into the record. All this was the crossing of affidavits between the two parties to the malpractice action. In the affidavit that the appellant put in, she iterated all of the things that she wanted to have done on her behalf, including the calling of witnesses.
Counsel, did your client testify at the trial? Did your client testify?
She did, Your Honor.
And didn't the appellate division indicate that at trial it was established that she had contributed little, if anything, to the growth of the businesses?
I know the appellate division said that, but that's not what the referee said. Think back in terms of the,
Did you appeal the appellate division?
no, I didn't know anybody at that time, Your Honor. If I had been around,
You
I
don't
would
have
have
to
got
know
my
anybody
first shot
to
at the Court of
appeal. It's not
Appeals,
like
maybe.
you call a friend and say, I'm going to appeal. But anyhow, you have time on rebuttal.
Thank you, Your Honor.
Well, you don't have rebuttal, I'm sorry.
Avram Turkel for respondents. May it please the court, we ask this court.
So on the one hand, the Cotton decision would seem to be a tremendous problem for this legal malpractice case. But isn't what counsel is saying is that, look, I lost that appeal at the appellate division because of things which should have been done at the trial level, which were not done by defendants. They didn't get an adjournment, which should have been sought, or they didn't make enough of an effort to get an extended adjournment, and other such things. And so therefore, doesn't the Cotton decision not mean that this case has to be dismissed?
Firstly, on those allegations of what was done at the trial, they are solely at the trial. None of the allegations can show, or do show proximate causation, but for causation required to defeat the motion to dismiss. Supreme Court properly dismissed on the statute of limitations, the analysis being the date of accrual, which is July 16th, 2015.
Well, is Supreme Court right about the statute of limitations? Because didn't the representation continue by defendants, but in a different firm? And wouldn't that representation be considered continuous, and therefore the statute of limitations does not become as simple as Supreme Court made it out to be?
No, and for a number of reasons, Your Honor. The flintlock analysis for a statute of limitations on a malpractice action requires first determining the date of accrual. That's undisputed, July 16, 2015, which is the date of trial. All of the allegations go to that. Then you determine 3 years from then the date the statute of limitations runs. That's July 16, 2018, right? At that point, the defendants, the respondents, have met their prima facie burden. The burden then shifts to the plaintiff to show that an exception applies. And Supreme Court rightly found that the continuous representation doctrine is unavailing, and there's a number of reasons for that. One, Bornstein-Scheinbaum, which conducted the trial in 2015, filed a consent to change attorney in January of 2016. Right? That consent to change attorney is dispositive documentary evidence. Two, Bornstein and Scheinbaum was out of this case. Sorry, apologies, Your Honor. Bornstein-Turkel was out of this case no later than October 16th, 2017. That is the date when Howard Benjamin, the appellant's lawyer, sent a letter stating that all documents should be sent to him, et cetera. Remember, this is a malpractice case. It is an action in tort, not in contract. The dates in retainer's agreement do not matter. What matters are when the attorney-client relationship broke down.
But I thought that there were the same attorneys throughout, although they just moved to different firms.
Well, they were not all the same attorneys. There was one firm with two.
That might help Scheinbaum, but it doesn't help Bornstein and Turkel, right?
I'm Turkel, Your Honor.
Right.
But
it does because
what
one,
date
there
was this action commenced?
When was this action commenced? September 30th, 2020, Your Honor. That is, what's important about the recitation of the dates, though, is that the statute of limitations had not run when Bornstein-Turkel was out of this case, was out of the divorce case on October 19th, 2017.
So how wasn't this started within 3 years of that October date?
Because the exception doesn't renew and restart the statute of limitations from that day. The exception says, look, you have a certain amount of time. The analysis is that you have a certain amount of time, accrual, date of this running of statute of limitations. That's set. Then they have to argue an exception to that rule. They have not met their burden. They do not show the ongoing reliance. They do not show the continuing representation. They make a throwaway line about successor counsel and just say it's so. And then on top of that, the plaintiff still had, right, from the date that Bornstein Turkel is out, she has 2 years.
Your cutoff is the letter dated October 19th, 2017, in which appellate counsel, I guess that's the counsel here, contacts you that he's taking over the appeal. So at that point, that indicates that the representation has come to an end.
Well, at that point, Bornstein Turkel's representation has come to an end, and you have what is really a superseding and intervening act of successor counsel deciding not to either inform their client to bring a malpractice action within the statute of limitations or to actually bring a malpractice action. The statute of limitations run.
Let's put aside the statute of limitations issue for a moment, but why, when he says, well, look, there are things that, there's a continuance which you should have sought to obtain, why aren't those issues problems for you on what is a pleading motion?
Because they do not show proximate causation. When I listened to argument, I heard a lot of could have done something, perhaps. That's not proximate causation. And Your Honor's point is really well taken. Their argument is about allocation, not valuation. Right? Valuation would be, all right, we have one expert, you should have put on another expert. There's an argument about experts, an argument about what the valuation should be. That's not their argument. Their argument is about allocation. That's Supreme Court's discretion, affirmed on the merits by this court. They cannot have a redo or an end run, as Your Honor mentioned. It cannot. So under any circumstances, we believe Supreme Court was correct on statute of limitations, but notwithstanding, they do not show proximate causation, they do not have but for, and though it is discretionary, we do believe that this appeal is barred by the law of the case. Just one last bit, Your Honors. There are a couple of items that were in appellant's brief that they're in the record on appeal in appellant's brief, which I believe are dehors the record. We asked the court to ignore them. Page 111 of the record on appeal is an extra page of affidavit that does not have NICEF stamp on it. There was a 3-page affidavit submitted through NICEF. This appears to be a 4th page that was just added. Appellants cite to the record on appeal in Cotton v. Rotobomb, which is not the record on appeal in this case. We ask the court to ignore it as dehors the record. Thank you.
Thank you.
Excuse me, you want us to ignore the prior decision that we issued?
No, Your Honor. The appellants in their brief cite to the record on appeal in another case, in Cotton v. Rotobomb. It is not within the record on appeal on this case. It is dehors the record on this appeal, as is page 111, and respectfully, we gave notice to counsel regarding that extra page. Thank you.
Thank you. Counsel, you didn't ask for any rebuttal. You did not ask for rebuttal.
I'm getting up to go.
Oh, okay. Thank you.
It's been a pleasure, though.
Take care. Flores v. Exotic Design and Wire.
May it please the court, Melanie Weiner on behalf of the appellant Exotic Design. Your Honors, this is a case where statutory liability associated with Labor Law 240 subsection 1 does not apply to defendant Exotic. Plaintiff did not meet his prima facie burden as he was not exposed to an elevation-related risk that would require a safety device contemplated by the labor law.
Let's talk about that for a second. So I actually looked up the term platform, and it's a flat horizontal surface that's usually higher than the adjoining area on which a person or things can stand, right? So are you agreeing that this was a platform or not?
Yes, Your Honor, it was an elevated platform. However,
okay,
this
so
court's
let's go. Okay, let's go to the next part then. So if it was an elevated platform, how does it not fall within the context of 241 when it was used by a worker performing that worker's duties?
Your Honor, this court in Fisher versus VNO, which two of your honors sat on the panel for and authored, is exactly on point. It was issued in April 2023, and it's now binding precedent. In Fisher, this court held that the plywood platform from which plaintiff fell was used by a worker to transport materials from a hoist to a mechanical room, and number one, did not serve as a functional equivalent of a scaffold. And
So how is this not the functional equivalent of a scaffold to the extent that the windowsill, which was going to be reframed, was 3 feet above the ground, and it could not be accessed because there was a bathtub?
Well, Your Honor.
And on top of that bathtub is placed a piece of plywood with a 4-inch overhang on which the worker is directed to stand to do that work.
Your Honor, actually, the worker had to kneel on the plywood platform because the work that he was required to perform was beneath him. He was 5 foot 4 inches.
So are you saying that it's dispositive, is that he was kneeling as opposed to standing or sitting?
Your Honor, the court in De Silva v. Toll First stated, in order for an elevation-related risk, for it to be an elevation-related risk, the plywood must serve conceptually and functionally as an elevated platform.
So Carpio says that a fall is gravity related when the hazard exists because of a difference in elevation. Are you arguing as to the height of the elevation?
No, Your Honor, I'm saying it was not functionally serving as an elevated platform. Maybe conceptually it was because he was told to stand on it, but the plaintiff testified that he could have done the work while kneeling in the bathtub, and he would have been required, if he had been able to stand in the tub, he would have had to kneel within the bathtub in order to perform the work.
But Exotic put the plywood over the bathtub.
Someone else put the plywood over the bathtub for cosmetic purposes only, Your Honor, in order to prevent scuffing the interior of the bathtub. The plywood was not there functionally to reach a height. As a matter of fact, there was no height to be reached.
So the plywood is over the bathtub. The only way in which the plaintiff, he's directed to stand on the plywood in order to repair or do whatever he's doing to the window. So if he's told to do this, I'm not understanding how you can state that there's no liability there.
Your Honor, he was told to do that. However, the standing, I don't want to even say standing, Your Honor, because he wasn't standing. He was squatting and kneeling because the work was below.
I don't know of any cases where there's a distinction drawn between when the worker is kneeling on a scaffolding or kneeling on a platform as opposed to standing on the platform.
The point is, Your Honor, it was not functionally serving so that he could do his construction-related work. It was there merely to prevent the scuffing of the interior of the bathtub.
How was he going to do the work?
How was he going to do the work? He could have kneeled in the bathtub, or he could have stand on the side of the bathtub in order to perform the work because it was lower than his height.
The plywood was blocking access to the bathtub, wasn't it?
That it was.
And he's the point of it?
He's told to stand on the plywood.
But Your Honor, the court in De Silva specifically said it has to.
Plaintiff summary judgment.
Right.
Sorry?
De Silva granted summary judgment to the plaintiff.
As the unsecured wooden plank served conceptually and functionally as an elevated platform or scaffold.
That's right, Your Honor,
That's
but
De
here
Silva.
it was not functionally serving as an elevated
Counsel,
platform.
what about the testimony of Mr. Arenas, who the exotic project super?
Yes.
Who said that it was standard for workers to work on top of the plywood protection?
Right, but it was not required in order for him to perform his construction-related job. The only requirement was by his boss in order to prevent scuffing. It was cosmetic purposes. He was not reaching a height.
Saying it's cosmetic purposes, but he's told to stand on the plywood. He is told that in order for him to complete his duties, to perform his duties, he has to stand on the plywood.
Your Honor, I would bring this court back to its binding precedent of Fisher versus VNO.
That's not what Fisher says.
Fisher does say that where the plaintiff
The platform
was
from
walking
which
on a platform.
the platform from which plaintiff fell was used by workers to transport materials from the hoist to the mechanical room, and it did not serve as the functional equivalent of a scaffold.
Exactly, Your Honor.
Here, however, the platform is serving as a functional equivalent of a scaffolding because it is covering the tub which he has to stand on in order to perform his duties.
He was not required to stand on that, only by someone who told him he had to, but in order to actually perform
Someone
the
who
work.
told him does not equal required?
Well, Your Honor, no, it's not required in order to perform the actual work. He testified it would have been better if he had kneeled in the
Rodriguez
bathtub.
tells him to stand on the plywood. Rodriguez tells him to stand on the plywood. How is he doing the job without standing on the plywood?
He could have kneeled within the bathtub or stood on the
But
side
that
of
would
the
mean
bathtub.
removing the plywood.
Your Honor, it did not conceptually and functionally serve as an elevated platform as required by De Silva and as required by this court in Fisher.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Janaros for the plaintiff respondent. As Your Honors have recognized, this type of work exposed plaintiff to an elevation-related risk. He was required to work on top of this platform cover in order to perform his work, which required him to access the windowsill and perform his window framing work at that elevation. As you all have recognized, there was no other way for plaintiff...
Well, he could have removed the plywood from on top of the tub.
Your Honor, Mr. Contreras was very clear in his testified that he was prohibited from removing that plywood cover. His boss told him you cannot remove it, and his boss instructed him to work on top of it.
I think the point is that the plywood wasn't necessary in order to do the job. The plywood wasn't there in order to make it possible for him to reach the area that he was working. It was there for the purpose of protecting the bathroom. So the plywood wasn't necessary to his work.
Your Honor, to that I would bring up again Mr. Salarina's testimony, wherein he fully acknowledged that it was industry standard for workers to perform their work, window framing work, on top of the plywood cover. And secondly, when we look at the context of the work being performed here, which is what we consider in determining if Labor Law 240 applies, plaintiff was required to stand and squat upon the plywood to perform his work. He had no other way to access it.
Counsel, if I may. Thank you. If I may, because counsel indicated that plaintiff could have stood outside of the tub to perform the work, but I thought there was some testimony that indicated that was impossible because if he did stand outside, that the plywood protruded about an additional 4 inches or so and would cap off the knee area when leaning over. So that was impossible to do.
You're absolutely correct, Your Honor. And in addition to that testimony, which came from the defendant's witness, Salarina, plaintiff testified at page 105 of the record, quote, "The reason why I ended up squatting down on top of the bathtub is because I otherwise wouldn't be able to reach that." He testified he couldn't do this work by leaning
counsel,
over.
Under 240, the plywood or what we're talking about would have to be the functional equivalent of a scaffold. The scaffolding is so that you can, the elevation so that you can do your work or what have you. Here, that plywood is not, according to your adversary, is not the functional equivalent of a scaffold because it was not placed on the tub or over the tub for the purposes of your client to do the window framing.
Well, Your Honor, when we look again at the context of the work, he couldn't reach it without being on the plywood, which couldn't be removed, which was placed by Mr. Manuel Hurtado, the exotics foreman. And this was being used by the plaintiff as the functional equivalent of an elevated platform because he needed to sit on it and stand on it to access the work.
Was it the functional equivalent of an elevated platform, or was it just the cover to the tub?
We submit that it fully served as the functional equivalent as a scaffold or elevated platform because that's what permits the plaintiff to do his work. How else would plaintiff be expected to perform this work? Defendant certainly has not identified any other way it was feasible for him to do his work. They overlook his testimony that he was prohibited from removing it, and they overlook his testimony that he was instructed that he had to work on top of it.
So, counsel, when Mr. Arena testified on behalf of Exotic that it was standard for workers to work on top of the plywood protection. Did Mr. Arena indicate at any point that there were options afforded to workers so as not to stand on a platform?
I believe he testified that a ladder could be used, but only if they were framing the top portion of the window. Here, he was only framing at the time of his accident the lower portion. That he couldn't, plaintiff testified he couldn't use a ladder for that because the tub was in the way. He couldn't squat on it.
Was there any testimony that a means of working from within the bathtub, protecting it in some other way, was available?
The fact of the matter is, Your Honor, he was told he couldn't remove it. So even if there was, plaintiff was instructed by his boss, you cannot move this plywood. It was prohibited. Plaintiff simply complied with the worksite instructions here that exposed him to an elevation risk. That was not adequately protected from because the plywood was unsecured. That's undisputed. It collapsed under his weight and it caused the plaintiff to sustain injuries that fall within the ambit of Labor Law 240.
Thank you.
Thank you, Your Honors.
Your Honor, to your point, the plaintiff did testify that had the plywood not been there, he would have had to kneel within the bathtub in order to perform the work because it was at such a low height. And the plaintiff would like this.
Did any witnesses testify that that option was afforded to the plaintiff?
Salarina testified that had the plywood not been there, he would have had to kneel that.
No, I'm not asking you that. Mr. Arena is the person, as I've quoted, who said that it was standard for workers to stand on top of the platform. Did he testify that other options were available that were actually used by workers?
I don't believe that that was asked of him, but the plaintiff himself testified that in order to do the job without the plywood, he would have had to kneel, evidencing that the elevated platform was not necessary and he could have kneeled within that bathtub to do the work. The plaintiff would like this court to believe that the reason why the plywood was placed on the tub is irrelevant and erroneously argues that Exotic created a safety device no matter what the reason. But the reasoning is important because it was for cosmetic reasons only and not for a safety device to reach a height. And this is dispositive, Your Honors.
Justice Counsel, I can understand your argument if there had not been a direction from the individuals on the site that he was to stand on the platform. If there had been a direction, you don't have to stand on it, or there had been some statement or something in the record suggesting that the plywood could be removed and he could go and kneel in the tub, I could certainly understand that. But what do you do, or how do we view the fact that the individuals, the supervisors at the work site, direct him to stand on the plywood?
It still does not fall under the ambit of Labor Law 240.
So there would be no remedy for his being told to stand on the plywood and then his being injured?
No, Your Honor, because it did not functionally and conceptually act as an elevated platform. And the court states in Rakovich, the Court of Appeal states in Rakovich versus Con Ed, that the requirement that Labor Law 241 requires a person to work on an elevated platform in order to be able to accomplish the task at hand has been confirmed by this court. And I, again, bring this court back to Fisher, which is this court's decision, because in that case, the workers were required by their bosses to walk on the elevated plywood platform in order to transport materials. And this court held that it was not the functional equivalent of an elevated platform.
Thank you. Thank you both.
Thank you, Your Honors.
People v. Dennis Logo. Or Logu.
Good afternoon, Your Honors, and may it please the court. My name is Aviva Galpert, and it's my privilege to represent Mr. Dennis Logu. Your Honors, the state cannot exhibit someone's body to a witness.
When did the state exhibit? I find this to be fascinating in terms of the the appeal of a denial of a wade, because I'm not even sure that identification notice had to be given pursuant to 71031B. But how was there any issue as to any suggestiveness of any identification?
Well, Your Honors, the threshold to establish the entitlement to a Wade hearing is extremely low. The Court of Appeals has repeatedly affirmed that all that's required is for the
Don't you
defendant.
at least need some kind of an identification
Yes,
procedure?
you do.
I mean, it's low, but you need an identification procedure.
Right, Your Honor.
So where is the identification procedure here?
So here, the identification procedure was a show up at the scene of the arrest, where Mr. Logu was displayed to a witness by the police, and during this confrontation, the witness positively identified Mr. Logu.
Identified the clothing, right?
Well, Your Honor, all we know for certain is that there was a positive identification that resulted.
Had a ski mask.
Well, the record is entirely unclear as to whether or not he was clothed. Certainly, we
so
agree.
if you
that,
have
like
a ski
most
mask and
defendants,
you're clothed, what part of your body? Where is the corporal identification?
There's no, the witness doesn't even ID. He just says that the person who burglarized or whatever the apartment, this is the burglary, were somebody in a ski mask.
Your Honor, respectfully, no. There is also a show-up identification. That is what notice of was given.
Identification. What is he identifying?
Yes, so there is no way of knowing that from the record, and that is why we needed a hearing. And Justice Gonzalez, I'd like to answer your question in two parts. First of all, again, we don't actually know the basis for the identification, nor do we know that he was wearing a ski mask at the time of the identification. That's really unclear. The prosecution's brief is actually inconsistent on that point, but regardless, there's no indication either way in the record. We know he had a ski mask with him. We don't know whether it was on him or not, but we would suggest that if he was wearing it, that would actually be an extremely suggestive identification. And then it would be sort of absurd to say that, yes, technically what's being identified as his clothing, but it's not just clothing, it's also his body type, his size, the way he carries himself. So it really is an identification of the person.
None of that was mentioned. Absolutely none of that was mentioned. The only thing that was mentioned was that the individual who burglarized these apartments wore a ski mask.
Well, Your Honor,
but in terms of identification, right, we're talking about the reason we have a Wade hearing is to determine whether any in-court identification is going to be tainted by any out-of-court identification. Is that correct?
Yes.
Do we have an in-court identification, or was there any in-court identification?
The question is whether it was going to affect Mr. Logu's decision to proceed to trial. That's the issue here, that and this is why we can't say that it was harmless, why harmlessness doesn't apply when there's a guilty plea. Again, we need an identification. Yes, and there was an identification, Your Honor. I'm sorry, I don't mean to interrupt.
No, I'm sorry, but again, I don't see in the record where there was an identification. I thought that the witness had called 911, the police came, right? And then the witness, and then they arrested the defendant, and then the witness said something to the extent that he had seen a man with a black ski mask she had seen a man with a black ski mask attempting to enter her apartment. And he's arrested that day and has a black ski mask.
Your Honor, there was a show up here. The VDF states people intend to offer trial testimony regarding an observation of defendant either at the time or place of the commission of the offense or upon some other occasion relevant to the indictment to be given by a witness who has previously identified defendant.
VDF further provided that the clothing the defendant was wearing and had on him included three ski masks.
Well, yes, so that is a separate piece of evidence, but we do note there was a show up here, and by saying that it was a mere clothing identification, all the people managed to do was to create an issue of fact that needed to be resolved at the hearing.
So counsel, some of the prior, I'm going to call them items, I don't know what else to call them, where a Wade hearing was not required, included a composite sketch by a police artist, victim's testimony about a tattoo, right? Tattoo. In Davis, back in 1996, the court found that witnesses' identification of a suspect's clothing, but not the face, did not require a Wade hearing. A shirt in 1995 in Anderson did not require a Wade hearing. And the same thing with clothing in Goodwin in 1994. So it's like, where are you going with this?
So a couple of things, Your Honor. First of all, in most of those clothing cases, so it's entirely different when the clothing is not on the defendant's body. Then it's more like an object. We would totally agree.
A tattoo is on a
There's no-
person's body,
A tattoo
right?
is on the person's body, but that case also was only resemblance testimony. There was not, it was not clear, and I'm sorry, it was clear that the witness actually could not produce a positive identification. They could say, yes, that's the tattoo, but they could not say that it was the same person. Here, all we know is that the witness said, yes, that's the person who I saw. And we don't know her basis for saying that. We don't know whether she, if she said...
Did the witness even say that's the person that I saw?
We know there was a positive identification from the show up. And, Your Honor, also,
I don't even know that the witness says that that's the person that I saw. I thought that the witness said that the person who I saw was wearing a ski mask. I don't know that there was even identification saying wherein the witness said that's the person.
well, Your Honor, the VDF indicates that there was a show-up identification, and that is where...
And the people actually responded by saying they just gave notice just to, you know, I don't know why, something like to be on the safe side or just to afford counsel that knowledge. But there's nothing really that I saw in the record. And if you can point me to it because I read the record, I read the transcript. I saw nothing where there was an identification.
Well, Your Honor, that's because there was no detail from what we have in the record. We needed a hearing to get those facts. And the people cannot dispose of the need for a hearing by merely asserting a conclusory fact, which is what they did here. We need that hearing. Mendoza says all they do by doing that is create an issue of fact. And Mr. Logan is entitled to a
Mendoza
hearing.
talks about physical identification, physical description and identification, not clothing. But
Right.
you have time on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. Connor Burns for the people.
So was there any notice by the people that there was a witness who identified the defendant?
Not the defendant, Your Honor. There was notice that there was an identification, but it was simply of the clothing that the defendant was wearing, the perpetrator was wearing at the time of the crime. And the VDF and the response to the defendant's omnibus motion make that quite clear. The VDF does say that there was a show-up identification, but then goes on to specify that solely the clothing of the defendant was identified.
So did the witness say that's the person, that the person who burglarized me is dressed the same as the person that I'm now looking at?
Well, that information is unclear from the record. That's not information that we're aware of. The only information that we are aware of that was, again, noticed in the VDF and then put into the reply to the omnibus motion was that the clothing, only the clothing of the defendant was identified, and that the only reason that it was noticed in the VDF was, as you noted, out of an abundance of caution.
And how did that identification take place? The clothing.
Well, that's unclear, Your Honor. It's unclear in the record how the process took place, but what is clear, and again, from the VDF and the people's response to the omnibus motion, that only the clothing was identified and not the defendant himself. It wasn't the defendant that said, the witness did not say that the defendant was the perpetrator. It was just solely the clothing he was wearing during some of the crimes
Is it possible that the defendant was wearing this clothing and the victim was asked to identify him and said, well, that's the clothing? Is it conceivable that that's what's happened?
Certainly, again, because it is unclear the manner of the procedure, but again, what is clear and what is undisputed, and defendant doesn't...
So if it happened in that way, why wouldn't a Wade hearing be required?
Well, I think, again, because of the clothing itself, I think doesn't have the same protections as it wouldn't count as a corporal identification because...
So you're not going to be presenting the complainant as coming into court and saying that's the person who did it?
Well, I think with our argument is that with what the information that was disclosed in the VDF and again further argued in the response to the omnibus motion was that solely the clothing was identified and again not the defendant's person, and that's why the Wade hearing was not warranted here.
And when you're referring to clothing, we're talking about a ski mask, right? Was there any other,
correct, and that's also the other argument.
Was there any other description of clothing?
Well, throughout the complaint in the VDF, it was noticed that he was wearing a Mountain Dew backpack and he had some sort of clothing on it, along with a ski mask. And I think that's why it could be conceivable as well that he was wearing the ski mask during some of the crimes that the perpetrator, the witness didn't see the defendant's face and wouldn't have been able to identify him, the defendant's person, would only have been able to identify his clothing.
Well, the witness has stated that the person who came into her apartment was wearing a ski mask.
Yes,
or as it exited or was entering the apartment was wearing a ski mask.
Correct, yes.
But your adversary makes the argument that this is information that the defendant would have needed in order to determine whether he was going to testify or how he was going to proceed with his defense.
Well, again, we did notice, again, out of abundance of caution, that there was this identification procedure. And again, we feel that it wouldn't have been entitled into a Wade hearing, again, because it wasn't a corporal identification. But in any event, identification wasn't an issue at trial in the case here because of a few different things.
It was a plea of guilty.
It was a plea.
Guilty. So there was never an identification offered in court.
Correct.
What we have is that there was some procedure in which the complainant said that that's the sort of clothing that the perpetrator was wearing, and the defendant knows that this has taken place. And what would the Wade hearing be? Whether the clothing was presented in a suggestive manner?
Perhaps, Your Honor. Again, we're not too sure what the extent of the Wade hearing would be because, again, even clothing, identification of clothing itself is certainly less suggestive than an identification of the actual defendant of the person. So certainly not sure what the scope of the Wade hearing would be, but again, we argue that it was certainly correct for the court to deny the Wade hearing summarily. And again, just to finish up again, because the error was harmless in any event, even if you do find that there was error, because identification was not an issue here. The defendant confessed to the crimes. He was caught on photographs and in videos during the commission of a few of the crimes. So again, identification was certainly not an issue here, and any error in the court's decision was certainly harmless. And for those reasons, we do believe that the court correctly denied the hearing, and if there are no further questions, we ask that you affirm. Thank you.
Your Honors, as you heard from the
So best case scenario for your position is that the people conducted some sort of procedure in which they put this clothing perhaps on your client and asked the complainant, can you identify the person or can you identify the clothing? And being that there was a mask being worn, the complainant is unable to identify the person. He says, that's the type of clothing that was worn by the person who perpetrated the crime. Now, when you're talking about a corporal identification, people look alike, it's easy to make a mistake. Ski masks, there must be 100,000 ski masks that are just the same.
Your Honor, it's not clear that he was wearing a ski mask at the time of the identification, and it was, at least there's a possibility that it was a corporeal identification, but this court does not need to decide
What would be the goal
that.
of this Wade hearing if you were to have a Wade hearing? What would be the point of inquiry?
Whether this was a suggestive show up, whether there was indeed a corporeal identification, which this court, of the person and the clothing on the person. And we do not believe that the clothing was put on Mr. Logan for the purpose of...
There's no identification of the person being contemplated.
Yes, but there was, Your Honor. He was presented to the witness. The clothing happened to be on him. He was presented to the witness. The witness said, yes, that's him. I recognize him in some
the
form or
witness said,
fashion.
I recognize the mask.
That's what they're saying now. But all that we know for certain is that the show-up produced a positive identification. And all we're asking for now is a hearing. If there was no identification of the person, the case will be dismissed. Nothing will change.
Of what? A positive identification of what?
She said, that's some form of that is the person I saw. That is the person who did it.
So the VDF said that there was that the witness made a clothing identification of the defendant.
That's what they say. So we need to know. We don't know what that means. We don't know whether he was wearing a ski mask, whether he wasn't. And again, clothing, it really can't be separated from the person when it's on someone's body. You can't separate it from their size. If it were someone
by the people that the witness identified a ski mask or clothing would not be sufficient for a Wade hearing.
Your Honor, we agree. But here they said that there was an identification of defendant. They gave notice.
Which they went on to say of the clothing.
Right, but their mere conclusory statement that it was only of the clothing is not enough. Mr. Logan needs an opportunity to probe that. He was entitled to that. The threshold for a Wade hearing is extremely low. You just need to allege that a suggestive identification took place. That's what Mr. Logan did here. And the reason it's so low is because the information about why something might have been suggestive is generally not available to the defendant, as it wasn't here.
You didn't make the argument, and I'm not saying that your point is not preserved, but the argument that you're making to us today was not the argument that you made to Supreme Court in your motion.
That's true, Your Honor, because the Supreme Court actually introduced this issue, really, and well, the prosecution introduced it, and Mr. Logo had already carried his burden.
You didn't say, Judge, we don't know what happened here.
Well, that's because by the time...
You should have put in a reply to what the people had to say and say, well, we have to know what happened here.
Your Honor, we don't believe that that was required. We believe that by making this argument, the prosecution could not have shifted the burden back to Mr. Logo. It, again, merely created a question of fact that a hearing was required to resolve. And by relying on...
No, but the people said there was no identification. They came back and said there was no identification, that the witness just simply said that not even identified, but said that the person was wearing a ski mask. So the point is, at that point in time, if the court is confronted with the people stating there's really no identification, you would have to come back and say, well, we don't know. We don't know what occurred. We don't know whether there was an identification.
Respectfully, Your Honor, we believe
Didn't it behoove you to add to Judge Weber's question, didn't it behoove you to come back and say, what do you mean there was a clothing identification?
That perhaps would have been prudent. I don't disagree with that. But what happened was that Mr. Logu said an affirmative identification took place. It was suggestive. He was not required to come back and say that again. And I'd like to note that in relying on Hightower and Douglas, the court below actually proves our point, because those are cases where there was a hearing that enabled the parties to draw out facts and to test facts and assertions, and the court to find those facts. Here, we had no such opportunity, and you can see that's resulted in enormous confusion. The people say, well, we don't really have to worry about it because we gave notice, but then they turn around and talk out of the other side of their mouth and say, we didn't really have to give that notice because there was no identification.
They probably didn't, but thank you. Thank you both.
Thank you, Your Honors.
Strawbag, Spa versus Credit, Agricole.
Good afternoon, Your Honor. Honors. Adam Laurie, I represent intervener Alto Maipo. The injunction at...
What is the basis for your claim that you had a right to draw on the letter of credit?
The basis for that claim, Your Honor, is that under the contract, Strawbag didn't achieve what the contract calls substantial completion. It's a defined term.
Is that because the tunnels collapsed?
I'm sorry, Your Honor?
Is that because of the tunnels collapse?
Indirectly, Your Honor, yes. The reason why we say Strawbag didn't achieve substantial completion is because certain tests had to be done before the end of December 2022, before substantial completion.
These were certain, the milestones.
That's correct, Your Honor. These tests...
They say under the terms of the contract, they had perhaps until March 31st to complete those tests.
Your Honor, at the outside, that's right. At the outside, they had until March of 2023. I would just point out, however, this is a contract issue that you're talking about right now.
Okay, but when I ask you about the tunnels, you say indirectly. Why isn't it your position, or why can't it be your position, that, look, there was no way that Strawbag could comply with substantial compliance by December 31st because the tunnels collapsed and they were responsible for the tunnels, whether or not that was their work.
That is our position, Your Honor.
It's their work, right?
I called it indirect, but that's our position. They couldn't complete the testing by December of 2022 because the tunnels collapsed. Therefore, they couldn't achieve substantial completion. Therefore, they should have paid us liquidated damages under the contract. When they didn't, the project was being bled dry. We needed money, and so we exercised our right to pursue the letters of credit with Credit Agricole. And in fact, Your Honor, the trial court's finding in this case on this very issue was that the parties had a legitimate dispute. There was a legitimate dispute about whether there was a breach of contract or not. Not an issue for this court. You don't have to decide that. But the trial court found that, and yet also found that there was fraud. And our argument is you cannot reconcile those positions.
I was going to ask you about that. So what relationship, if any, exists between the repeated extensions that were requested and provided because of the weather, right? You can't test when it's frozen or freezing, and the collapse. What is the relationship between those two? Are those two separate events? Does one, was the request for extensions relevant to fraud, that there was really hanky-panky going on? What say you?
What I say, Your Honors, there was no extension granted. There was an acknowledgement that testing couldn't occur in the winter in Chile. In other words, last May through roughly last August. There was an acknowledgement, you can't do it. There's not enough water in the tunnels to conduct these really important tests. There was also a statement, however, by my client that you still have until December. And don't forget, it's going to be summer in Chile in September to December. And so wait until then. You have a deadline of the end of December 2022 to conduct these tests. If you can't do it by then you get this further extension that His Honor was talking about until March. But we never got that far because the tunnels collapsed. And so the tests, by the way, they were underway. My client had started them, and it was only because of those tests, Your Honor, that we discovered the collapsed tunnels. And once we discovered the collapsed tunnels, that was really the end of the story. We had to drain the tunnels of water. It wasn't safe anymore, and the repairs had to start. But the other point to your question, Your Honor, is that everything we're talking about right now, His Honor asked me, these are contract issues. These are issues the parties are fighting about in a parallel arbitration that's going on right now. This is not fraud. We have one argument under the contract, you weren't excused. They have another argument under the contract. They say we were excused, we were excused from doing the test. That's a contract fight. That's not fraud. And the statute at issue in this case, UCC 5109B, it makes crystal clear that where there's a legitimate dispute, just like the trial court found, that's not fraud, period. And that should have been the end of the story with the trial court. These types of letters of credit, as you know, these are routine in large construction projects like this. And they're routine to protect, in our situation, the owner from being bled dry while there's a contract dispute. They've refused to pay us liquidated damages. We bargained for the right to keep the project afloat by drawing down these letters of credit. That was our right under the contract. Now, Alto Maipo paid Strawbag $1.2 billion. That came out of our pockets and flew into the contract pockets of Strawbag. We paid him $1.2 billion. And what we got in return, Your Honors, are tunnels that have collapsed, a project that shut down, and we can't access the letters of credit that we bargained for. My time is done. I'll reserve my last 2 minutes.
Yes.
Good afternoon. Steve Reinhardt for the respondent, Strawbag. I'm struck by a number of things, but the first thing I'm struck by is that counsel has not mentioned, and indeed in the papers below, never referred to Amendment Number 2, Section 17, which really governs what happened here. Section 17 expressly states that the contractor shall be excused from any delay in achieving a guaranteed critical milestone date due to the unavailability of water necessary to perform owner's testing. Now, the trial court, in the exercise of her discretion,
where does the tunnel collapse fit into that?
Frankly, Your Honor, it doesn't. Because Amendment Number 2, entered in May of 2022, pursuant to which Alto Maipo actually received and took control of an operating facility. Let's be clear. It was completed, and they were running it.
But by the end of December, the project was supposed to pass certain tests.
The water test, Your Honor, yes.
The water test, right. When the tunnels collapse, doesn't it become impossible for you to establish substantial compliance?
Substantial compliance, Your Honor, is in fact an issue for an ongoing arbitration. But let me talk about why there's fraud here.
That may be, but the question is whether there's fraud when they try to draw down on the letter of credit.
Yes, absolutely.
So is it fraud? Is there no colorable right to that letter of credit when they drew it down after they become aware of the collapse of the tunnels?
No, and here's why. Amendment number 2, section 17, expressly permits the contractor to be excused from any delay in achieving a guaranteed critical milestone date. That was December 31st. That's exactly what happened, and Altamaipo acknowledged it month after
That may be
month.
exactly what happened. Let's grant you that is
Yes.
exactly what happened. But it also happened that the tunnels collapsed, and you're never going to be able to pass that test.
At that point, the extensions were already in place. In other words, the recognition by Altamaipo and the plain terms of the contract.
And that's your position.
Push that back.
That amendment gave you, and you claim it gave you until the end of March.
And in fact, they denied substantial completion for that very reason until December.
Does it matter what their reason for denying substantial completion is if the facts on the ground show that it's impossible for you to establish substantial completion?
No, and the reason why is that what occurred in December can't be used to retroactively undo the extensions and the protections from liquidated damages that Strawbag bargained for and got in Amendment number 2.
So is it your position they should have waited until March 2023?
Our position is that the critical milestone date was extended pursuant to Amendment number 2, and the correspondence from Altamaipo for the previous 6 months was extended past December 31st of 2022, and in fact, should have been extended about 6 months, which would get you...
So beyond March 2023.
So March 30th of 2023 is the long stop date. After that, they can't get liquidated damages. They might have an argument about breach of contract, breach of warranty, and they can litigate that all they want, but they don't get the liquidated damages.
Counsel, I want to go to Section 17,
Yes.
Part 2 of Amendment 2. I'm going to paraphrase again. Delays resulting from the unavailability of the water necessary to perform the testing or any other acceptance tests would entitle your client to an extension of time if that delay prevented the achievement of substantial compliance by the guaranteed critical milestone date of December 31st, 2022. So we can agree that that is the language, right?
That, Your Honor, paraphrase it, but that is the gist of that.
Okay, right. So can't we say that this language never came into play because the delay wasn't because of the unavailability of the water, but the collapse of the tunnel?
I don't think we can say that, and I don't think Justice Maisley...
Can you tell me why?
Yes, I'm going to tell you why.
Okay.
Because delay due to the inability of the contractor or the owner to conduct certain tests was due to the lack of water from May through December, correct? And that entitled Strawbag to an extension of the critical milestone date of December 31st. So that had already happened. Altamaipo had already informed Strawbag, we're denying substantial completion because there's a delay due to a lack of water and we can't run the tests.
I want to go back.
After that delay, that extension was already appropriate, earned under the contract. Altamaipo said in December, because we have a tunnel collapse now, what happened before is off the map, no extensions. Amendment number 2 doesn't count. Section 17 doesn't count. And that's where the court below found the bait and switch. You deny substantial completion based on a lack of water, and when December comes, then there's a different problem, and we can talk about whether that problem has got anything to do with critical milestones.
All right, I want to
It doesn't.
go right back to the tunnels.
That switcheroo in December is where the court found that there was fraud.
But there's no dispute that the tunnels that did collapse, right, that your client designed that and built it, right? The tunnels.
Yes.
And then they collapsed, which prevented any other work. That's a yes or no?
Okay. That's, yes, our client constructed the tunnels. It has not been determined, and this is very serious, it has not been determined that Strawbag was responsible for the failure of those tunnels. Remember,
I didn't say responsible. I just said, no, listen to the question. I said, designed, that's a yes, right?
as I understand it, yes.
Okay. Built, that's a yes.
Yes,
Right?
yes.
Then somehow they collapsed.
Yes.
That's it. Thank you.
Okay.
So the point you make about this is a breach of contract issue, et cetera, but that's not really the inquiry that we face when we're talking about drawing down on the letter of credit.
That's correct.
We're concerned about the issue of whether there's material fraud in drawing down on the letter of credit, where the standard is where material fraud by the beneficiary occurs only when the beneficiary has no colorable right to expect honor, and when there is no basis in fact to support such a right to honor. So what you're saying is that collapse of the tunnels does not provide even a colorable right for Alto Mapo to come back and say, we're entitled to a draw because there's no way that Strawbag is ever going to provide substantial completion by the end of December or in any date near that.
I understand Your Honor's question. The answer to us is that this is not a mere contract dispute, that it fits within the analysis of the fraudulent transaction exception to the independence
No
rule.
colorable right.
Exactly, because Strawbag had established and it had been agreed that it was entitled to extensions of the critical completion date of December 31st. Correspondence from Alto Maipo for 6 months saying, not enough water, you're denying substantial completion. Not enough water, denying substantial completion. And in fact, go look at section 17,
But at that point,
which
even
gives
if
us
there
the
was-
extension past the December 31st date.
But at that point, even if there's enough water, you're not passing the tests because of the tunnels.
Right, so why would the tunnel collapse, therefore not give them arguably a colorable right to draw down? Because it's never going to be completed.
Because what would happen then is that, A, the critical milestone date has been extended, and B, you then get to the long stop date, March 30, 2023, after which they can't take liquidated damages for missing the critical milestone. They can't. They may have other claims, and there's a contract and there's a warranty which they conceded was in effect because they had operation and control.
When was the tunnel collapse? When did the tunnel collapse?
I didn't hear you.
When did the tunnel collapse?
Mid-December of 2022.
Mid-December 2022.
Correct. At that time, as Justice Maisley found, the refusal to grant substantial completion because of a lack of water had already been communicated multiple times to Strawbag. And Section 17 they'd been referred to sections, look at Section 17, they said. We're not giving a substantial completion because there's not enough water. Section 17 says we get the extension. It was done. And here's what Justice Maisley said, which I thought was interesting. It goes to the issue of what's in dispute. While the parties have a legitimate dispute about whether Strawbag achieved substantial completion, the owner, that's Alto Maipo, has no plausible explanation for agreeing to excuse failure to achieve substantial completion due to water shortages in exchange for taking control of the plant earlier than allowed in the contract, but disavowing Strawbag's rights in Amendment 2 with two words, collapsed tunnels.
Isn't there a difference between excusing substantial completion because of the lack of water and excusing a substantial completion because the tunnels have collapsed? I mean, I'm wondering whether from their point of view, whether there's a difference, because I think there's a difference between lack of water and then the total collapse of the tunnels.
Right, but substantial completion with a capital S is a contractual concept. The facility was complete, it was handed over in May of 2022. They were operating it. They were running it at their risk. They were making the money. They were getting the revenues. It was operating. So that's a different issue from getting the test done by December 31st. And as to that, We had the absolute right to an extension. They recognized that we had the right to the extension, and the court found that you can't take that away, that 6-month bump of the substantial completion date, you can't take that away
But as a
because something else happened.
As a practical matter, we're talking about a preliminary injunction. So, I mean, it could be determined later on that there should not have been a drawdown, right? And then they would be liable to you for the monies that were taken?
And remember that on a preliminary injunction, a number of
You
factors,
make-
including...
You make that point very well, but the tension with it is that to say that there's no colorable right to draw on the letter of credit when it becomes clear that you can never satisfy the substantial completion date on time, that to draw on that letter of credit constitutes fraud, that's the tension with your position.
Well, it's
I mean,
that with the
you make the point
extension...
well, but it's up against the fact that you're never going to comply.
Well, after March 30th, 2023, that obligation goes away. That's the long stop date. After that, they can't collect liquidated damages as a matter of contract. So
They contest that you had a date to pay substantial to the end of March.
they do, but the court below found that the contract is crystal clear on that scope. And the other thing to bear in mind, and I recognize, I apologize, I'm past the red light, is that the court clearly found a danger of irreparable harm. Because if, in fact, the drawdown occurs, that is the last Strawbag will see of
They've
those
been in
funds.
insolvency and
And they talk about in their own papers on this appeal and below, they're on the edge of bankruptcy.
Thank you.
Thank you, Your Honor.
There was never an extension. Strawbag keeps alleging there was an extension of time, that Alto Maipo gave an extension of time. Alto Maipo never did that. That may be their assertion. But the fact is, as I said earlier in response to the question, the substantial completion date was the end of December of 2022. The testing had to occur by then. That's all we said. With respect to the issue of the long stop date, Your Honor's point is very well taken. It's the one we've made, which is the tunnels here have collapsed. There's no way to achieve substantial completion. The testing couldn't occur. Your Honor, we sit in the middle, Your Honors, we sit in the middle of New York City. It's not a difficult concept to think about. You build a huge building, and the idea is you're not going to let it become fully operational until you test the fire system, until you test the sprinkler system, until you test all of the safety. So their claim that we were somehow operating the project, and that negates our liability, makes no sense under the contract. The way the contract works is we were allowed to use the project at a commercial way, much in the way you could occupy a building partially before it's fully ready. And then once the testing occurs, which is critical, then you can achieve substantial completion. I just want to refocus the conversation for a moment. Again, we paid out of our pocket $1.2 billion for this project. It's not working. It shut down. And they're trying to stop us from drawing on a letter of credit, Your Honors, with a breach of contract argument. And Your Honor is absolutely right. The standard is no colorable right. But this argument, was substantial completion done? Wasn't it? Does the long stop date give an extension? Was there a water extension? These are all contractual issues that are being fully argued in front of the parallel arbitrators right now. Your Honor, I would just close with urging you to look at the language in the UCC, the New York UCC. You're supposed to come to this hearing with skepticism about a claim of fraud. And I appreciate the pointing to irreparable harm. The fact is, the irreparable harm that will occur here will be to my client, the people of Chile, and to the New York system, which encourages people to bring letters of credit here. That's where the harm is going to occur if the trial court's opinion stands. And lastly, Your Honor, my client, it's an international player. We chose New York for this letter of credit because these are supposed to be enforced. And now we're left, as I said earlier, being bled dry, no money, and we've paid out $1.2 billion to Strawbag.
Thank you. Thank you both. SJWA versus Father Realty.
May it please the court, Frank Winnick of Amity, Demerson, McManus for Father Realty. Hi. The crux of this case is whether or not the sanitary line that Father Realty had was trespassery. And the answer is it was not. That there was a deal that was made between Father Realty and plaintiff's predecessor, and they said that they would make a joint shared sanitary line that ran through the plaintiff's property. Each of them paid 50%, and Father Realty obviously opted not to do its own line so that it would have a line through plaintiff's property.
So, counsel, there was a subsequent, what would you call it, a renovation, replacement?
Yes, there was a
Pipes in
renovation, yeah.
2013, if I recall correctly?
Yes.
Does that sever that relationship between the prior, well, whatever would inure to the present property owner? Does that sever that license or that agreement?
No. That what I'm saying is that we have an irrevocable license based upon the payment of money and a change in position, which was to have that joint sanitary line. And so it could never be revoked because then that would be unfair to Father Realty, who had paid money and had changed his position. And I think the law from this department is clear, and from the Court of Appeals, that licenses can be revocable or irrevocable. And here, again, because they paid money, they entered into a joint agreement that you cannot revoke that license.
So what are your responsibilities as to that license? The backups, the sewage backups that are complained of are very, very significant, it appears.
I agree. And so what I will say is, and I'd like to just put for 1 second what I think the proximate cause is to say that this line was running from 2007 to 2018 with no problems whatsoever.
And at what point did C7, what is their
Chelsea 7.
Chelsea 7, at what point do they become tenants?
2017.
So the license is granted in your eyes between the prior owner and your client. The sewer system or the connections work. They're approved by DOB. Okay.
Actually, it's more importantly that it was.
But let me just.
I'm sorry.
It's okay. You have a tenant in 2017, and in 2018, all these backups begin. What was your responsibility? I mean, what's supposed to happen here?
What is supposed to happen is, again, the notice, and I think the dates are very important, in particular as to notice to us that they did this renovation in 2013, and they say that our line was extinguished at that time. And they say that that is the reason that they're having the problems because of our sanitary line.
But I'm going to concede that.
Okay.
For now, just for now. You have a problem where condoms and gloves and diapers and raw sewage are coming in through somebody's basement drains, their shower drains, and they are affecting the basement to such extent, it is alleged, that the sewage goes above the baseboard, which is more or less 6 inches, and it's so bad that the walls are affected. They are tainted by all of this by 6 feet. What was your responsibility?
Well, in talking of when we learned about it, we didn't learn about it until December of 2018. And so there was nothing that we could do because we didn't know about it. There was this
So
phone
when you
call.
learn in 2018, is there anything in the record that shows that you served notice on your tenant or that you commenced a proceeding against your tenant or that you assumed any responsibility to remediate the situation? I mean, they're asking for punitive damages. They're saying that they have a viable claim for punitive damages because basically you crossed your arms and you did nothing. So what did you do?
Well, and it's a question of when what we did, that in 2018, our client told Chelsea 7 not to use the bathrooms. Now, we are an utterly out-of-possession landowner, and so we could only do something when we find out about it.
Okay, so what did you do in 2018 besides telling your tenant? I'm sorry I'm saying your, but you know, it's not you.
I understand.
Right? What happened? Because I don't see anything. I see signs in the bathroom that say, don't use this. But did you say, look, we got to lock up your bathrooms? What did you do?
Well, it's when we knew that there was a problem with them. We didn't know that there was a problem with them until the Department of Environmental Conservation.
Did you need to know that it was a problem with them? I mean, you knew there was a problem. So once you learned of the problem, regardless of whether it was a problem with them or whether it was a problem with the line or what have you, did you not have some responsibility to do something? And what did you do?
We didn't know what to do. There was no backup in our building. And so what happened in a call around just before Thanksgiving, when the plaintiff tried to contact us, apparently she got the managing agent, who was the son of the owner.
And this is 2018?
Yeah.
Thanksgiving 2018?
Yes. And so she said, oh, we're having this problem. And she wanted to talk to his father, not to him. But so what he did is he went to the building to see if there was anything in the basement. There wasn't. He knocked on the door to the plaintiff's house. There was no answer. So he wasn't aware that there was anything to do.
How long, there are these allegations of this massive flood in plaintiff's basement. For how long did that flood go, for how long did that condition continue?
Well, in
I mean,
Thanksgiving.
there comes a point in which there's really massive backup in plaintiff's
That's
building.
correct.
At what time is that alleged to have occurred?
It's just before Thanksgiving of 2018.
Okay, and so what happens with the backups, what does the record show as to what happens with the backups after Thanksgiving of 2018? I mean, was there a continuation of many feet of water in plaintiff's?
No, absolutely not. There were some seepages that occurred that the plaintiff called up a roto-rooter type people and that they fixed. We didn't get notice of that. We didn't have notice of this.
So there's a one-time massive flood in plaintiff's basement.
Yes.
Which you don't know about before at all.
Correct.
And then you're notified about it and you tell your tenant to stop using the bathrooms. But there isn't a continuation of this massive flooding of plaintiff's basement after that Thanksgiving 2018 days. Is that correct?
It is. The only thing I'll say is that we told them in 2018 not to use the bathrooms, and that when this Thanksgiving flood occurred, that we went to see if we could find out what the problem was. We didn't find anything. And the first notice...
So what did you do to try to find out what the problem was?
We went to our home, and we went to the basement, and the basement was clear. There was nothing in that basement. He then literally went around the corner, knocked on plaintiff's door. There was no answer.
And when was that?
That was just before Thanksgiving of 2018.
Mm-hmm.
And then we heard nothing else. Now, there were these additional seepages that occurred, none like the one that happened just before Thanksgiving. And the plaintiff took care of it. And at some point, she calls up and she says, she tries to get to the father to tell him there's a problem. And we're not aware of anything. And so what happens is eventually the plaintiff files an action and a preliminary injunction, And this is in 2019, just a few months afterwards. It's not that there was a length of time that we didn't do anything. This happened just before Thanksgiving, and then actually between Christmas and a week after New Year's, there was absolutely nothing that was going on in her basement.
Counsel, what about the results of the December 10th, 2018 dye test? Because didn't that place your client on notice that there was something going on and that you should have taken some action?
I'm going to say no to that, because the dye test did show that water flowed from our home to their home, but that's part of the shared line. And there was actually, we had an expert take a look at it, and of course this was afterwards. There was a test, a visual viewing of the sewer lines.
I gotta ask you a question. You keep saying home. I understand it's a sex joint on the second floor. Wait, what, is that what you're calling your home?
No, the home I'm referring to was the plaintiff's residence.
Ah,
Yeah, no, I'm,
okay.
The dye
I got
test-
confused.
The dye
No.
test doesn't reflect, or does it, that there is a backup in the plaintiff's home?
no. It shows only that water flowed from my residence to the plaintiff's residence. That's all
So
that.
when you say flow, where in the residence did it flow to?
Into their line. There was no flood that was created as a result of
In
this.
other words, the sewer line in their building reflected that water from your building was entering their building.
Entering their
Their
drain.
sewer line.
Yeah,
Not-
but
Not that there was a backup.
correct.
And who ordered the dye test? Was that something that you?
The plaintiff did.
You have time on rebuttal. Who do we have? C7? Chelsea 7?
Good afternoon, Your Honor. Scott Gertman for Chelsea 7.
So you can tell that I got things mixed up a little bit, right? When he was saying home, I was like, oh, Lordy, why is he calling this sex joint his
Yes,
home?
he's
So let me ask
did not live there.
Let me ask you, what remediation efforts were undertaken?
Chelsea 7 had absolutely no idea of any of this until there was a court proceeding brought. As under the
Well,
record,
he said, Father Realty said that they came to you in November, Thanksgiving
that
20.
there's nothing in the plaintiff called, was trying to track down the owner in, I think, Pakistan, was having trouble getting the number. This took a process until there was a court proceeding. At the inspection, it wasn't until after, I think, in 2019, when my client was told anything.
Well, at some point in time, there were signs in the bathroom. Do not.
There was always signs in the bathroom, like any other public bathroom. Do not flush inappropriate items. There's nothing my client could do. It's a bathroom that the customers use.
I don't understand. Is Chelsea 7 also known as Sexy Boutique?
What's that?
Is Chelsea 7 also known as Sexy Boutique?
Yes, it's a shop that sells adult items.
Right.
At a store.
So the plaintiff said that when she went over there were tubs of condoms and tubs of.
They could have condoms there. That doesn't mean
No,
they're
I'm not.
flushing
I'm
them
not
in
saying
bulk
anything
down
against
the
condoms.
toilet.
Don't
It
get
doesn't
me
make any-
wrong.
Right. It doesn't make any sense.
I'm just saying what kind of inquiry was made and what type of remediation was made. You're saying not.
What type
we
of
didn't know-
inquiry?
we
Once
didn't
the
know
issue-
anything
Wait.
happened.
I'm sorry. Go ahead.
You're saying we didn't know anything happened and it's just a bathroom.
Okay. Let's back to the beginning. When we signed the lease in 2017, we have no idea that these lines are connected. That's an issue between the two of them, whether there's a proper connection or not. We have no idea that anything that happens in our bathroom is going to connect to a multi-million-dollar apartment basically on the other side. So we have no idea there's any connection of the lines at all until after this litigation commences, after this major flood occurs. That's a fact. That's not even in dispute. So we have no idea at all. Once this occurs, our bathroom is closed. We don't have use of the bathroom. So my clients testified, this testimony case, they couldn't use the bathroom wasn't available. My understanding, the bathroom hadn't been available for years after until they kept the line.
Kankana Malage said that he told workers not to use the toilet, but workers and customers may have used it anyway. That doesn't sound like a bathroom that's closed.
It was closed. This is a very short time period. The issue, the bathrooms were completely capped, and the lines were capped in April of 2019. The primary flood, which are the damages in this case, there is no dispute that in November of 2018, my client has no idea the lines are connected. He has no idea anything that he's doing in his bathroom has any connection next door. The residual seepage, which may or may not have happened, we could have an argument about what was caused or not. But again, I want to just address the primary issue that I see in this case.
So who knew what before the major flood?
Who knew what before the major flood?
Before the major
The owner knows that his lines are connected to the plaintiff's lines. I will let the plaintiff address whether he knew that those lines were connected or not, but
Does anyone know about this potential for a major flood because of the connection?
certainly my client does not. I don't have a dog in that fight, so I'm going to leave that to these two parties, because I certainly have nothing to do with the plumbing inside the walls and connecting. I signed a lease in 2017 for my premises, and that's it.
So November 2018 is when the major flood occurs, right?
Correct.
You said something about the lines being capped, or the
Lines were, I believe, capped in April of 2019.
2019.
Right, and then but I do want to address the damages issue, which I really think is the central issue in the whole case that cuts through everything else, because at the end of the day, this is a property damage case. She had property damage, she was paid by her insurance, that's it. The law is very clear that you get the repair costs or loss of value, whichever is less. That's a fact, that's a clear case law. She's been paid, that's it. There's nothing there. There's no one who's even arguing or claiming that after April of 2019 there's any issue at all. It's over, it's
So
done.
you're saying that the claim for punitive damages was properly dismissed, am I right?
It should be dismissed. There can't be punitive damages as far as my client is concerned. He doesn't know the lines are connected. It can't be punitive damage or even trespass for flushing his toilet or having customers flush his toilet. That can't be punitive damage. It's shocking to the conscience. He has a bathroom that's open to the public.
Well, it depends on what you're flushing down the toilet. Right?
He has no idea what, if a customer is flushing something inappropriate down the toilet, he has a picture on the thing. Do not flush, just like any public bathroom in this bathroom. I could go into your bathroom and flush anything. There's no one who's going to know anything about
The
it.
question is whether he has any reason to believe that the use of this, the continued use of this toilet will lead to a major flood in the plaintiff's basement.
He does not, and certainly there's not even a claim that he does at the time that the primary flood in this case happens, which is really all the damages in the case. When the flood happens where the sewage rises up the wall, that's in November of 2018. There's not even an allegation that my client has any idea the lines are connected at that time.
So your client is allegedly notified after the flood.
My client.
Your client is notified after the flood, after November.
Yeah, there's no one who's claiming that he says anything to my client before there's not even a claim.
And is there any claim that anything occurred after the flood, after November 2018?
That there's claim of, like Counselor said, some seepage and things like that occurred after. But the primary claim, again, even if we accept all of her property damage, let's accept all of it, all the way from November up until April, that's been litigated with their insurance carrier. They paid $40,000. That's the full claim. They're making some claim now that there's some stigma because there was a sewage flood in 2018, that if she tries to sell the property in 2023 or whenever this trial happens, that someone's going to say, oh my God, there was a flood 5 years ago, so now I'm only going to pay. There's no case law. There's nothing anywhere to support this. It's pure speculation by definition. There was another sewage backup at the same property in 2006 with fecal matter that went into the property. So there was another issue with the sewage line. So if there was some stigma, that was already there. So there's no way a jury could count. When she put the house on the market, which she testified to in November of 2018, there was no buyer, there was no offer. So we have not even a baseline of what she could have sold the property for in 2018. And again, we have no baseline of what anyone's going to buy it for in 2023. So that is the absolute definition of speculation. There's no concrete evidence of any damages of what it could be. So at the most, we have a property damage claim, which was about $40,000, of which she got, I think, I don't know, $35,000, whatever the numbers are. And that's it. But again, there's no claim anywhere. My client signs a lease. He has no idea these lines are connected. He played no role in connecting the lines. That's between the two of them. I don't have a dog in that fight.
And the original, it's not your point, but the original connection of the sewer lines was because there was an agreement between Courtney, who was a previous owner of plaintiff's property, and the owner of defendant's property at that time.
I'm nowhere near that. I have nothing to do
But
with.
those are the facts as they appear in the.
Those are the facts, and again, that's between the two of them. But there's no claim that when I sign my lease, I have anything to do with that.
Thank you.
Good afternoon, Your Honors. Benjamin Horowitz on behalf of the plaintiff. I want to start by just first correcting the record a little bit with respect to the backups. So, Your Honors, as we've discussed, the basement initially flooded in November of 2018 around Thanksgiving, and that was the massive flood that we're talking about here. But then, Your Honor, the record is clear
So
that the sewage...
at that time, had your client complained to anyone that they were using her sewer line, or that there was a problem in her basement?
Yes, Your Honor, at that time, and I think counsel for the defendant said that his client was notified at that time that there were sewage backups.
After the flood.
After the flood, exactly, Your Honor.
Before the flood.
Before the flood, no one had any idea that there was a connected line. Well, my client didn't. And so after that time, Your Honor, from November until January of 15th, 2019, the sewage flooded the basement on a daily basis, and that's at 928 of the record.
And that was reported, was that reported to the defendants?
I believe it was, Your Honor, but really what we're alleging is that notice here was clear.
There was a massive flood in November.
That's right.
What was the flood that occurred? You're saying that there was a daily flood afterwards. What was the nature of that flood?
So that's what the defendants were calling seepages, Your Honor. The nature of that flood is that it was a combination of essentially raw sewage, but also detritus, such as condoms, rubber gloves, all of these items that obviously shouldn't be put.
But you know, homes frequently have sewer backups. There's a sewer pit in which water comes in, and it's obviously unpleasant and, you know, not something you want to see or smell. But is that what we're talking about? Because you have this massive flood in November in which the walls are getting soaked with water, there's major damage. Or are we talking about a sewer backup of what one thinks of more usually, that there is some sort of sewage backup, but walls are not getting wet?
So, Your Honor, I think the extent of the backups that occurred between November and January 2019 were certainly not the massive flood for the initial flood. However, they were not what you would call your standard flood in the sense that they contained items that are generally not found in sewage, such as condoms, rubber gloves, and construction debris. So at that point, Your Honor, the plaintiff undertook testing, extensive testing, to determine the source of the backups and determine...
But I want to just get back to notice. So the notice to Father Realty was only in November 2018, or was
December 2018, Your Honor. That's what the court below found. I mean, there is evidence in the record to find that in November of 2018, that...
Notice is only after Thanksgiving in December 2018.
That's right. And as to Chelsea 7, Your Honor, in January 14th, 2019, there was a cease and desist letter that was sent directly to the premises of Chelsea Boutique. And there's an affidavit of service in the record saying that a Chelsea 7 employee received that cease and desist letter. And that letter outlined the extensive testing that was done to prove that the source of the backups was the defendant's property. At that point, Your Honor, they must have been on notice of the backups and the source of the
your
backups.
adversary says that the testing, if you're talking about the dye test, showed that there was water from defendant's property, from Father Realty, in the sewer line of your property.
That's right, Your Honor. But I would just correct the record slightly on that point, Your Honor, because what the dye test shows is not just that material flowed from defendant's property to the plaintiff's property. What is in the record, and it's at 929 of the record, is that the dye was flushed down the sink of the defendant's property and bubbled up through the grates in the basin of plaintiff's property. It wasn't simply that it was in the line. What it showed is that the backups were being caused by the defendant's property, not simply that there was a physical connection between the lines.
So your adversary says that when they received notice that there was a massive flood, Mr. K I have to look for his name to pronounce it properly. He came over and nobody was home. So that was the end of that, because he figured nothing else is wrong. As to the cease and desist letter, what remediation, if any, took place, or what communications took place from the defendant's side to the plaintiff's side?
So, Your Honor, as is clear from the record, I think, the only thing that the defendants did is that they came to the plaintiff's property and knocked on the door, and when she wasn't there, they determined, as you said, that the problem was solved. It's not clear why they would have determined that the problem was solved after that. And, Your Honor, after this case was initiated in the trial court, there were continuous backups, and the defendants were under a TRO to cease and desist from the court using their property in a negligent manner such that it caused sewage backups, and they failed to do that.
Chelsea 7 said that the lines were capped in April of 2019.
Yes.
If the lines are capped in 2019, then there should not have been any further backup, right?
And there weren't, Your Honor. There were no further backups after April of 2019, but that's because, again, the lines were capped and the physical connection between the properties was entirely separate. But before that time, and the lines were capped, Your Honor, pursuant to a court order, that wasn't something
January
that,
15, 2019 is when you had the dye test, right?
the dye test was December 10th of 2018. January 14th was the cease and desist letter that was served on Chelsea 7, Your Honor.
Fine. Any backups between January 14, 2019 and when it was capped in April?
Yes, Your Honor. There were intermittent backups at that time. And the trial court was made aware of those backups. They were essentially of the same nature as the initial backup, just smaller in scale, Your Honor. So they were sewage backups containing detritus not generally found in sewage, but they were slightly smaller, and the plaintiff, as counsel for defendant said, cleaned them up.
Defendant Father Realty says there was an agreement between the owner of its property, and Courtney, a prior owner of your property, for the line to be joined.
Yes, Your Honor. And so the key point there is that the license agreement, if it existed at all, was between Father Realty and the plaintiff's predecessor in interest. So there's nothing in the record to suggest that the plaintiff was a party to that license agreement or that she had notice of the license agreement when she purchased the property. And licenses, critically, Your Honor, don't run with the land. So when the plaintiff purchased the property in 2010, 4 years after...
When the plaintiff purchased the property, was Father Realty supposed to dig up the sewer line and change the sewer line at that point?
Well, at that point, Your Honor, I think as a legal matter, the line was trespassery. But really, critically, for purpose of this case, what we're saying is that once they had notice of the backups, the nature of the backups, and the fact that the backups were caused by their property, they were required legally to essentially lock the bathrooms and ensure that the backups didn't occur, and they didn't do that. No one in this case did
I
that.
asked you about the cease and desist letter. What remediation efforts, if any, were made? I would assume that you have the cease and desist letter here, you have the initiation of the court action there, and then in between at some point you have the capping of the...
Yes, Your Honor, no remediation efforts were made. The only thing that happened was that Chelsea 7 says that they had a sign, which they said existed before the backups anyways, saying don't flush anything down the toilet that you're not supposed to. And then apparently the landlord asked their tenant orally to stop using the bathroom in trespass. But there was no physical remediation attempted. No one locked the bathroom. There was really nothing undertaken at any point before the line was capped. And again, that was pursuant to a court order to stop the backups here. And that's really the basis for the punitive damages claims here, Your Honor. There was nothing attempted to be done, despite the fact that they were on notice of massive sewage backups containing items such as condoms, rubber gloves, all that kind of detritus, and they did nothing to attempt to stop it.
Thank you. Father Realty, you have 2 minutes in rebuttal.
Yes, thank you. I'll try to be quick. In reverse order, Father Realty did not have control over these bathrooms. And so I just want to talk about the fact that we told the tenant what to do. If the tenant didn't do it, I understand at some point it becomes my responsibility, but we were out of possession landowners, and it's their responsibility to do this. And
you know something? We definitely understand what an out-of-possession landlord means, but you're talking about a major health hazard. You're talking about a major health situation here. I don't get it.
I think that there's a problem. We need to look at the record. And if you talk about the 928 is what counsel said is where you've got the everyday backups, and that's just not true. And so when you look at our briefs, and I know we've all put it in there, you're not going to find proof of daily backups.
So in the record, after the cease and desist letter is received, what in the record shows that you took efforts to remediate the situation?
None.
Okay.
But the question is, what is my obligation and what is their obligation? But more importantly, this is less of a problem than I think the court understands. And it was the plaintiff that did all these things. And so there was the first sewage that in 2006 is because the corner property severed our lines. That's what the sewage was in 2006. And it went into the pit that had been dug for the new bank to be there. There wasn't anything into any of the homes. They built then a new sewage line. In December 26 of 18, plaintiff complains to DOB. On the 28th, it's inspected, and they issue a report, no violation. So it's not as if we knew all these horrible things were happening. Things may have been happening, but we weren't told about them. Okay, I get it.
When was the no violation issued?
Okay, and on December 26, the plaintiff calls the Department of Buildings.
And Department of Buildings comes down and does not issue a violation.
Correct, they inspect and do not issue a violation.
When did I do the dye test?
I'm sorry?
When is the dye test done?
The 10th, before this.
Before that.
And
So are you arguing that there was nothing for you to do because the plaintiff was doing everything? Because the plaintiff was taking all the steps to try to figure out what was going on, so therefore there was no onus on you to do anything?
No, the point is we didn't know about any of this, and I'm saying that I understand that the plaintiff was doing things, but it's not as if there is as much as plaintiff as.
But what you have is that in November there's a horrible flood.
Horrible.
And then afterwards, the situation, while clearly one which should not continue, is not of major. There isn't major flooding going on.
And I would characterize it as minor, and it's not even flooding. That just material comes up that when our expert did the visual exam, there was nothing wrong with our sanitary line. And he said that there was something wrong with the trap in plaintiff's property. That is in the record, it's in my papers, and it's in our expert report.
Thank you.
Just 30 seconds if I could have. What went on with this is, again, there's no violation at the end of December. There's no backup from the end of December till the 7th.
What about the cease and desist? The cease and desist goes to
Came on
Chelsea
January
7.
14th.
Yeah. So you have notice as of then.
What would you want me to do? And I'm sorry, I don't mean to ask that rhetorical question of the court.
The cease and desist was a letter from plaintiff to?
C7, right? Chelsea 7, or to you as well?
They mailed it to the address. We're in Pakistan. It's not as if, they sent a fax or they sent.
Okay, but the cease and desist letter outlines, according to plaintiff, outlines everything that had occurred and what was going on in terms of the backup, et cetera. Is that correct?
No, if you look at the cease and desist letter, it's very vague, as I pointed out in my papers. We were not on notice of this continuing problem, and I will tell you that the record does not support there's this continuing problem. And so these actions were taken in a very short period of time when we didn't know much, and there wasn't really the problem that we're talking about. What happened in November was horrible. Our expert said our sanitary line was fine, and there was a trap under the plaintiff's basement drain, and that's in the record.
The plaintiff asserts that there were backups and seepage from November through April.
Yeah, that's not correct. Totally not correct, and the record will reflect that in our briefs. You refer to our briefs, and you're going to find that. And when counsel referred to page 928, if you take a look at that, you're going to see the extent of it, and it's not going to show what I think is in your minds as to what the problem is.
And the cease and desist is, of course, it's not a court order, it's a letter.
Right, but again, not a letter that we got that day. And then shortly after that, literally then in February, they go into court for preliminary injunction, which is granted, and then a capping order, which is granted. So there was nothing for us to do by the time we found out
And the
anything.
capping order is complied with.
Of course, yeah, but not even by us. They capped it. And they capped it to the point where we could still see where our sanitary line ran and then was capped and wouldn't go into the plaintiff's property.
Thank you. Equitable Financial versus Shanti.
Good afternoon, Your Honors. May it please the Court, Scott Horn, counsel representing the appellant, Karen Shanti, in this matter. Your Honors, the motion court erred in awarding a pre-answer dismissal to the broker on the grounds that it did not owe a duty to Ms. Shanti as a matter of law. The record clearly shows that the broker dealt directly with Ms. Shanti, its longtime client, at the time it provided her with wrong information, prepared and submitted wrong claim forms, provided her with erroneous policy summaries, failed to uncover these errors, which would have been evinced had they checked their own records, and erroneously advised Ms. Shanti that her beneficiary status was irrefutable. Under well-established common law principles in this state, this direct nexus between the broker and its longtime client, Ms. Shanti, engendered a duty to speak and act with care, and upon which she was entitled to reasonably rely. But we submit, Your Honors, that under this case law that we cite in our briefing, what's dispositive here is that Ms. Shanti is not seeking redress as a mere member of the general public. To the contrary, she's seeking redress as the particularized recipient of the broker's commercial activity. This is the direct nexus between the broker's commercial activity and the plaintiff, Ms. Shanti.
Did Ms. Shanti have any obligation to make inquiry as to why all of a sudden, out of the blue, she is the beneficiary of the decedent's will as opposed to being the custodian for his son?
She did not know anything about the policy until she found out that she had been named as a beneficiary. She was specifically told by the broker who procured the policy and established the beneficiaries under the policy that she was, in fact, a beneficiary. She was given summaries by the broker, which identified her as a beneficiary. She received a check from the insurance company that said Karen Shanti, beneficiary. So I think under the totality of the circumstances, A, no, she certainly has the right to reasonably rely upon all these representations that are made to her, both verbally and in document form. And B, to the extent there was any conversations between Ms. Shanti and the broker specifically represented to her that any challenge, and this is 6-8 months after the fact, that any challenge by the mother of the brother's son was meritless. And the reason why the broker could say that was because the broker is the one that established the beneficiaries. So we submit, Your Honors, that this direct nexus between the broker and Ms. Shanti is what renders the Vestal case inapposite here. The Vestal case is the third department case that the lower court applied as being on point, but in fact, it's inapposite. The rule that was applied in Vestal is not the rule that's being applied here. The rule in Vestal was whether the broker had some duty to say something at the time the policy was procured. Here, we're not talking about the procurement process, we're talking about the payment process. And in connection with the payment process, there was this direct interaction. In Vestal, there was literally no interaction between the plaintiff who claimed to be a beneficiary and the broker. So we submit, Your Honors, that under the circumstances, given the absence of any direct nexus or interaction whatsoever between the broker and the plaintiff in Vestal, that Vestal should not have been applied. That rule should not have been applied in this unique context. In fact, we submit that this context is so unique that this is a case of first impression in the state. I was unable to uncover any case that remotely approximates this situation, and Respondents' Counsel hasn't cited any cases in their briefing which approximates this situation. And the last point I'd like to make on that is that this is a pre-answer dismissal. Even if there was some sort of duty or reasonableness of the reliance, that's a triable issue of fact as far as what was her obligation to undertake certain actions before she relied. That's inherently a question of fact. What we're dealing here is a 3211 motion.
Thank you.
Thank you, Your Honor.
May it please the court, Your Honors. John Darminio for the respondents, Mark Goldstein Associates and Mark Goldstein. Respondents take the position that there is no duty here, obviously, as we put forth in our briefs. Absent any duty or any functional equivalent of privity here, Mr. Goldstein's putting together of the policy form was merely something he did.
Well, he was her principal financial advisor, right?
Well, the third-party complaint states that Mr. Goldstein, or excuse me, that Ms. Shanti was at one point a client of Mr. Goldstein's. The affidavit put forth in response to our motion to dismiss goes into further detail that there was supposedly a longstanding history of 15 or so years, and that.
But if he tells Shanti that, don't worry about it, that money is yours, doesn't he bear potential liability for that sort of a misstatement?
Well, Your Honor, that misstatement was made in response to a letter from legal counsel for, I believe, Ms. Alfina Shanti, the mother of the beneficiary, the intended beneficiary. Mr. Goldstein's not an attorney.
If he represents to Ms. Shanti that she doesn't have to worry that money is hers, it's all going to be okay. If that's the way it happened, I mean.
Well, I think that's, respectfully, I think that's a little bit of I don't.
Isn't that enough to survive this dismissal motion?
I don't believe it is, Judge. I believe that the fact that someone was contesting whether she was a beneficiary or not, or an attorney.
A financial advisor, and he tells her, "Don't worry, that money is yours," and she goes out and.
But there's a legal challenge to whether or not that money is hers. He's not an attorney. He knows that he knows that when Equitable provided him.
Said, I don't know what the status of that is, not to tell her, well, don't worry about it, that money is yours.
Well, yes, but so as counsel points out, that happened 6 to 8 months after her receipt of the payment, which I believe was in July of 2019, shortly.
Okay, and now she's got to give the money back.
Yes,
but it really starts hurting. And he tells her, don't worry about it, and she may have done things or spent on things which she otherwise wouldn't have.
But again, you're looking at Mr. Goldstein or the brokerage here as an expert in a field where they're not experts, law. I mean, the fact that he says to her, I think this is without merit, is in part based on the fact that she received payment from Equitable as a beneficiary on the policy. It is not as if he said, hey.
Let's accept what you say. But if he's a financial advisor and he doesn't know, shouldn't he have kept quiet about that?
Well, I mean, again, I think in the context of a conversation where, hey, someone's challenging this and, well, listen, you received payment as a beneficiary. I don't think you have anything to worry about. I don't know that you can take that at face value as an expert opinion here from a broker when.
But there had not been a lawsuit as of yet.
There had not been a lawsuit, but there had.
So at this point in time, she receives the proceeds from the insurance company. So he, as her financial advisor, someone who she has sought advice from in the past, he tells her that his expertise, his understanding is that she can keep the money, right? So it's not really giving legal advice, it's more giving advice in the context of being a beneficiary under an insurance policy.
Well, under the insurance policy, well, at the time of payment, she was listed in Equitable system as a beneficiary. So arguably, whether or not that is correct on Equitable's part, she was a beneficiary and received payment.
Right, so she relied upon his
I mean,
statements to her.
She relied upon the receipt of the payment to materially change her lifestyle. She relied on receipt of the payment in July of 2019.
That coupled with his statements to her that she shouldn't worry about it.
But at the point that she received payment in July, and as a third-party complaint puts forth, she then, in September of 2019, undertook certain life, changing, her employment, changing, undertaking debts of others, changing, in one instance, procuring another policy. Those are all the genesis of her receiving the payment.
Can we back up a minute?
Sure.
So, Mr. Goldstein helped the decedent, while he was alive, obviously.
Correct.
He helped him to change the beneficiaries of the policy.
Correct, Judge.
Right?
Yes.
And his sister was supposed to be the custodian for the minor and get a 33% interest for that minor, right?
Correct.
So at the point where Equitable makes a mistake and says, oh no, it's the sister who's the beneficiary, no action is taken by the person who submitted the application on behalf of the decedent?
That error takes place. It's not as if that error took place, 2 weeks after she received the money and then changed her lifestyle, down the road, where arguably, yes, that makes sense. Hey, we made an error before, we just issued this check. We need you to put the brakes on whatever, you may have in store for these funds. This happened further down the road. So, I mean, to put all of this on the broker, I think is a bit, is a bit disingenuous, for lack of a better term, because he's merely executing the death benefit form at the request of the insurance company to issue proceeds to the listed beneficiaries. And in this instance,
Who helped make the change of beneficiaries?
the change in beneficiary form was, in one instance at least, performed by Mr. Goldstein.
Oh, isn't that the operative fact?
Well, that was the operative. In 2016, he made that change. In 2019, the decedent passes away, and when the brokerage reaches out to Equitable to see who the named beneficiaries are, again, for whatever instance this was, she's listed as a beneficiary. So he cannot, for him to, he submits the form as Equitable lists the beneficiaries out and submits the death benefit form to them, and she receives the payment.
Thank you.
Thank you.
Very briefly, Your Honors. I think that one of the more important aspects of the case, as was pointed out by Justice Friedman, it wasn't just that the broker was saying, don't worry about it. There was this long-standing relationship, financial advisor relationships. So the broker's not just saying, don't worry about it. The broker's saying, don't worry about it, invest your money with me, which takes it even one step closer as far as the nexus and the privity. And I think that's an important lens through which to look at all these actions and omissions on the part of the broker. The second point I want to make very briefly is that respondents said, well, it's disingenuous to put all this on the broker, but nobody's putting it all on the broker. We're just saying the broker is responsible as Equitable may be responsible, right? So there may be more than one proximate causes of damages under tort theory, whether it's negligent or negligent misrepresentation, excuse me. Again, to the extent that argument is being made here, that, well, she was really damaged because she received a check from Equitable, well, that's a question of causation. And that's another triable issue of fact. And that's something that shouldn't be decided on a 3211 motion. If there are no further questions from the panel, I'll be happy to rely on my briefs.
Thank you.
Thank you, Your
both.
Honors.
Kellet versus Light Tower Fiber.
Good afternoon, Your Honors.
Oh.
It's our contention on this appeal that the motion court erred in dismissing the plaintiff's Labor Law 240 claim on the grounds that plaintiff was not engaged in protected work activity. The record here shows that the plaintiff was working as part of a large-scale fiber optic cable installation project under the streets of the Bronx. This project that he was working on encompassed no less than 20 manholes and underground vaults. According to the testimony, this required the installation of heavy metal racking systems on the walls of the underground vaults, which were used to keep the fiber optic cables up off the ground and out of the water that accumulated in the bottom of the vaults. This work also required the removal and replacement of concrete conduit pipes that were running between the vaults.
So,
In this,
I assume you're arguing alteration, but what exactly was altered?
so we submit, Your Honor, and we have case law that supports the concept that, for example, I think the best example out of all the work that he was doing, the installation of heavy metal racking that are wall-mounted, bolted into a concrete wall in an underground vault is clearly an alteration of the structure. So the structure in that, looking at it from that perspective, the structure is the underground vault. It's part of this whole system. They are altering it by bolting these metal racks into the walls of the structure, just as in any number of cases that we've cited involves reconfiguring sprinkler systems, chiseling a hole in the wall in Joblin, which is a Court of Appeals case, installing air conditioning ductwork, running wires up a ceiling and connecting into trusses. That's all alteration work because you're altering a structure. Here, even if you leave aside the replacement of the concrete conduit running between the vaults, the fact that they're drilling into the walls and mounting heavy metal racking systems clearly constitutes a structural alteration under the common law.
The Supreme Court said that based upon the record, that your client was simply feeding cable through a pre-existing hole.
That's right, Your Honor. So we submit that that analysis, which looks at only what was being done at the moment of injury, is erroneous under the Court of Appeals decision in Pratt's. In Pratt's, the court very clearly instructs that the courts must not isolate the moment of injury and ignore the general context of the work that was going on here in determining whether a plaintiff was engaged in a protected work activity. That quote that Your Honor just made reference to from the lower court, that's where the lower court went wrong. The lower court went wrong because it looked at just this one discrete activity rather than the overall scope of the work, which is what Pratt's requires, as well as Saint from the New York State Court of Appeals. And that's where the court went wrong on the issue of protected activity. And then once you move beyond protected activity, the court also found that the 30-pound industrial vacuum that was permitted to slide down an incline and fall into a manhole 6 feet and strike the plaintiff on the head did not need to be secured as a matter of law. There's no case law cited to support that. It's just the motion court saying it. But in actuality, Your Honor, there are two different things that should have been done. Not only should the industrial vacuum have been secured, but under the contract, there should have been a ring manhole protector, a ring guardrail in place that would have slid down into the manhole and been able to protect it from items from falling in. And thirdly, what they did use, the guardrail that they did use, which was not what they were supposed to use, was open. It was three-sided. So it's a three-sided barricade. There's an unsecured industrial vacuum that weighs 30 pounds with wheels on an incline, and it rolls down like a golf ball going into the hole and topples over.
Were there supposed to be chains or something across the manhole that were
That's right.
picked up and
That's
not
right.
put back? Could you refresh my recollection?
It was a three-sided barricade that should have had heavy chains going across so that I guess you can get in and out of the barricade more easily. That was not done. But more importantly, when we look beyond the barricade and we look at what the lower court actually found, the court's determination, and I see that my time is up, if I could just quickly make this one point, the court's determination runs afoul of this court's decision in Rincon, where this court found that where one worker was working at height and another worker was working below, and a wrench slips from the elevated worker's hand and falls down and strikes the worker below, that's a labor law 240 claim because that wrench should have been secured. We submitted an expert that said that vacuum should have been secured, and frankly, we don't even need an expert. It seems common sense under the circumstances.
Thank you.
Thank you, Your Honors.
Light Tower?
Good afternoon. My name is David Schultz from Barry, McTiernan, and Moore. We represent defendant respondent Light Tower Fiber New York Incorporated in this action. The lower court did not get this one wrong. In determining that plaintiff's work was not covered by the labor law, lower court properly determined that the pulling of wire, pulling of fiber optic cable from one end of a hole to another end of a hole did not constitute alteration as a matter of
Wasn't
law.
this part of a big project? I mean, we weren't dealing with just pulling a wire from one hole to another hole.
This portion of the project, and as the case law talks about, when you can differentiate a project into separate phases, this phase of the project was simply running cable. There would be other phases of the project.
But not just between these two manholes. There were other manholes involved too, were there not?
There were, but it was the same job being done at each manhole. They would run wire from one manhole to the next, manhole to the next. The entire project was running cable. And as the record clearly shows...
What would be the justification for bifurcating that job in the fashion you're suggesting so as to call it not alteration? I mean, you really wouldn't think of this as discrete, separate jobs. This is one project.
The project that was going on at the time, the purchase order that was issued by my client to Hellman was to run cable through the mainline conduit. There was going to be a separate part of the project.
It's just between the two manholes?
Not between the two manholes, between numerous manholes.
I thought it's a 20 manhole structure, right?
There was, I believe the contract is even more than 20. There were, the work was to run cable.
Right, but that's the point. How do you just focus on one section when ultimately the cable is going to be connected through the school? I mean, the whole point is that there's going to be Wi-Fi, internet, or whatever to the schools. So at some point in time, you need the running of this cable through these manholes in order to get to the schools.
Right. Where the two phases are is the purchase order that was issued was to run the mainline conduit. That was the job that Hellman was doing pursuant to this purchase order. No other work was going on at the time.
It's a little bit hard to consider this sort of a project not an alteration.
I would say, in what way? When I say in what way, all Mr. Kellet and his coworkers were doing on the project that was being done pursuant to the purchase order was running cable.
So there were no changes made to the walls with racks, as
None.
your adversary said?
There were other portions of this project where maybe that was done. On what was being done here, the record is very, very clear. The Hellman workers, Light Tower workers, were not allowed to make any changes whatsoever to the manhole.
Let's talk about the manhole and the protection or lack thereof, and the vacuum that had wheels.
Sure.
So is it your position that the protection around the manhole was adequate so as to protect people from things falling through?
I would point out that when looking at the enumerated devices set out in the labor law, a barricade is not an enumerated device that is articulated in the labor law. The cover that is described in the record is a cover that is designed to prevent people from walking in. That is the concern of the work being done at this job, not materials falling in, not tools falling in. The concern is pedestrians walking into the hole.
You're not talking about height. You're saying that the height differential between where the workers have their feet and the sidewalk above doesn't make a difference?
I'm not saying that the height differential doesn't make a difference. I'm saying in the context of the labor law, where in order to prove a violation, it must be shown that the absence of an enumerated device was a proximate cause of the accident, that the record herein does not show the absence of any enumerated device. The barricade is not an enumerated device. As far as the evidence in the record that plaintiff's expert said about the ropes and the pulleys, he said that a rope should be present because the vacuum fell. That goes against all of the labor law jurisprudence that says just because an object falls does not mean the labor law is violated. And that was the only reason why plaintiff's expert said that a rope should be present, because it fell. No other explanation.
So as far as the barricade and the chains, in particular the chains, there were across, that would normally have been across the manhole cover. You're saying that that was adequate?
I'm saying that a barricade is not an enumerated device. And furthermore, the vacuum, in order for the barricade to even come into play, the vacuum has to be an object being hoisted, being secured, or an object that needs to be secured for the purpose of the undertaking. Clearly, this vacuum was not being hoisted. Clearly, it was not being secured at the time. Now, the question becomes, is this an object that needed to be secured for the purpose of the undertaking? No. Plaintiff's work did not involve this vacuum anymore. Plaintiff's work was going to involve the snake. Right at this point, this vacuum served no purpose whatsoever and was not required for the undertaking that Mr. Kellet was performing.
But it was there anyway.
It was there anyway, but it was not an object that needed to be there, so it did not need to be secured for the purpose of the undertaking.
Would you agree that it was there perhaps because the rest of the project in which this particular piece of work was involved was incorporated?
I would agree that the reason why the vacuum is there is that it is part, when I say part of the job, it is a tool that is used. However, it is not a tool that requires securing for the purpose of the undertaking.
Thank you. ECS?
Good afternoon, Your Honors. Katie Lee Wright, Lewis Brisbois Biscard Smith on behalf of Verizon and Empire City Subway Company Limited. I would like to first address the claim of the racks. I would implore you to look at all of the testimony. At no point is there testimony that installing the racks means drilling into the side of the manhole. In fact, they are not allowed to make any structural changes to the manhole, but specifically, plaintiff testified that he installed racks, which are shelves. Shelves do not require being drilled into the side of a wall.
I'm sorry, Counsel, you represent Verizon?
Verizon, which owns Empire City Subway Company, is a wholly owned subsidiary of.
Right, so it's really ECS, right?
So really, it's just ECS.
Okay, because you talked about Verizon, and I thought that Verizon's motion had been granted.
Yeah, I apologize, Your Honor. I represent everyone.
Okay.
Everyone left.
ECS, thank you.
Yes. There is additional testimony by plaintiff's coworker, Mr. Mazziello, that they would never, in his 18 years of employment with Hellman, ever make any structural alterations to a manhole. And there is also additional testimony by my client, Dan Turgeson, that racks are pre-existing structures in the manhole that subcontractors may add upon, but not make any structural changes to the walls themselves. Changing or adding to, using, I believe he used the word ties, a couple of other words to lift up the wires that they were running.
So your position is that there were no alterations going on?
That's correct.
So the four-person teams would just open up a manhole cover as is, jump in, put the fiber optic cable through and pop out? End of story, done, and then you keep going to the next one and the next one until they finally hook up with the school?
So I will actually tell you that the school is not in play here in any capacity. The work order was for Hellman to lay 14,555 feet of fiber optic wire between approximately 100 manholes. It did not in any capacity involve extending to the school. Yes, it was part of a larger project.
So all they had to do was put the cable. All the workers had to do, the electricians had to do, was jump into the hole, plug the cable into some device, some conduit of some sort, run it through, and pop out. There was nothing else involved.
Well, they climb down in a ladder and they
Well,
use a snake. They
That's
rope and rod.
That's the easy part.
Yes, they use a snake essentially. The conduits exist, and they have to find just a pathway through this conduit to run their own wire, which is already tons of other
This
wires.
was
in it.
easy peasy. Just
I mean,
plug in, plug out.
I don't do it myself, so I would never say it's easy, but does not involve any alterations. Sometimes, my understanding is sometimes the wires get stuck. They have to use a special tool, but it's essentially like a very long rod.
So
That's why it's
basically,
called
your
rope and
argument,
rodding.
you agree with the argument of Light Tower that this is a distinct operation and had nothing to do with ultimate alteration or connection to the school buildings.
Yes, and I welcome a Saints and Pratt's analysis of the totality of plaintiff's work. He testified that he had been working on this project for 2 months. He was working for Hellman pursuant to this specific work order, and this specific work order was solely to run fiber optic cable through pre-existing telecommunication conduit system. At no point in the record is there anything about drilling or altering any structures. I understand that there is a larger project that there is testimony about that would eventually involve bringing this internet system to the schools, but that is not part of the project that plaintiff was working on, and there is no guarantee that he would be picked up as a contractor for the next portion of this project, or that Hellman would even be assigned this, as the testimony from Light Tower is that they have an ongoing...
Is that a requirement? Would that be a requirement that he, we know that this is part of, I know you want to distinguish and you're going to say that they're separate projects, but is it not one project in terms of delivering the fiber optics to the school? Is it not one project and this is, just a portion of that project?
It is one overarching, the project is called Light Tower DOE project, and the overall purpose is to bring fiber optic internet to the schools in the Bronx. So yes, it is one project. I actually don't know how we can even say that there would potentially be drilling into the schools at some point in the future, except for the one extremely vague affidavit submitted by someone named Edward Fonda.
How else would we get the fiber optics into the school?
The record does not say how it happens.
Thank you.
Very briefly, Your Honors. The notion that was represented here, that the only thing that they were doing was pulling wires, is disavowed at page 295 of the record, which is Christopher Kellett's testimony about what he was doing at the time he was injured. So this is not trying to create some sort of illusion that these disparate aspects of the project were happening at all these different times. The racking was being done right then and there. So at page 294, 295, well, actually, before I get to that, page 235, I apologize. Question, what were you doing at the time the accident happened? Adding pipe, by the way, not snaking. Adding pipe, yes. That was the job that day? Answer. We were snaking the manhole, pulling the ropes in, putting the pipe in, and racks up. That was the job for the day of the accident? Answer, yes. Moving down to line 14. When you say racks up, what do you mean? Installing racks. Thick metal racks with arms on them to put the wires and stuff on them to keep them off the ground. It's like a shelf. And then you move to page 294, 295. He once again says at the bottom of 294, we put the racks on the wall. Question, do the racks go on the same wall that the pipes are in or in other walls? On the side walls. Question, when you say the racks are on the wall, that is at a right angle to the wall that has the pipe openings in it? Yes. So I think, Your Honor, the testimony here, again, this is summary judgment now. The testimony here clearly indicates that they weren't just simply using a massive fishing line or rod or reel or whatever to thread fiber optic cable, but they were actually altering the structure inside the vault. And if there are no further questions, I'll rely on my papers. Thank you, Your Honors.
Thank you. Board of Managers versus Hong. Afternoon,
Good
you're ready.
afternoon. May it please the court. Anna Hong, defendant appellant pro se. This case was brought by plaintiff respondent to foreclose on liens placed on my condominium unit for the alleged failure to pay common charges. There is no dispute that plaintiff respondent improperly credited the May 2018 common charges to fines penalties that had been pending since 2011. Once the common charge payment had been improperly applied to the $6,000 fines, as matter of law, defendant appellant had to repudiate that action and cease payment. Continued payment would have resulted in a waiver of all affirmative defenses. And that's the case of 13th and 14th Street Realty case and the Edison Stone case. The waiver of affirmative defenses, that argument was not raised in the lower court. However, I respectfully submit that the court may still consider the argument. It appears on the face of the record, it involves no new facts, is determinative on the issue, and it was raised earlier this year in February, so plaintiff has had notice of the issue. And that's the cases of Peralta and Fascia Libre.
Do you acknowledge owing anything?
Excuse me?
Have you acknowledged owing anything by way of your common charges?
I would say that due to plaintiff's actions, I do not owe any amount since I had to stop paying since May 2018, since they took the action of misapplying the common charge to the fines.
So what's the total amount?
The total amount would be the common charges from May 2018 to the present.
And minusing 6,000, how much is that?
I
More or less.
have not.
So you say that because they misapplied $6,000.
The May 2018.
Right. That
I
you
had
don't-
to cease paying,
that you don't-
otherwise.
You don't owe anything? All of that money?
Yes, until this litigation ends. Otherwise, all of my affirmative defenses would have been waived.
Ms. Hong, I know that plaintiff now has waived the fee, so that's a non-starter now. The $6,000 doesn't matter. So we're talking about the common charges, the late fees, the interest, and the attorney's fees. So since we're not dealing with the late fees, let's assume they were Tomber. Let's assume that. What's your position regarding your responsibility regarding everything that I stated since the $6,000 is off the table?
First of all, plaintiff did not make that offer until after a decision had been issued on the motion to dismiss. So that is to hoard the record.
Because I'm looking at the brief, page 15.
Right, I stated that in my reply brief. Secondly, since payment would have resulted in the waiver of all of my affirmative defenses, I could not pay, and I still cannot pay until this litigation is over.
But there's also case law that, you can pay under protest. What about that?
Well, I was making payments under protest. I was making payments under protest of the common charges while protesting the amount of the $6,000 penalty fees. But then they misapplied the common charges to that $6,000 penalty fees. Now, plaintiff respondent states that there is a duty to pay common charges that is nearly absolute, but I was paying the common charges, and to this day, I would have continued to pay the common charges had they not diverted application.
But now
of
you're
the
not
late-
paying anything. Is that correct?
Exactly.
Right, and
Otherwise,
so
all my affirmative
we were talking about $6,000.
Yes.
Now we're talking about $72,000.
Correct.
So even if they misapplied it to the 6,000, there's still, was that $66,000 that's left, right?
Right, but there are other affirmative defenses other than those. So had I continued to pay, all of my affirmative defenses would have been wiped out based upon, let's say, illegality, which I've raised. So it wasn't just the $6,000 affirmative defense of disputing the House rule. It's much greater than that the waiver would have applied to. It would have
see.
applied
You
to
have-
all of it.
You have time on rebuttal.
If I may, just really briefly, let's go to page 256 of the record. I think that's the ledger. Now, because I believe it's your contention, right, that this ledger sort of indicates that they misapplied the common charge. So we put that aside, but does this ledger, well, let me ask it this way. Does this ledger address the non-payments by you on here, or any payments past May 2018?
Yes, there was a ledger applied, submitted by the plaintiff, a full account ledger going from when I purchased the apartment to whenever it was submitted. So I purchased the apartment, I believe, in 2004, 2005. And that is part of the record. So it has all the payments until whenever it was submitted. The motion to dismiss was made in, however, a couple of years ago. So it has all that data.
Thank you.
Good afternoon, Your Honors. May it please the Court, Allison Stavis for Plaintiff Respondent, Board of Managers of Residential Section of the Galleria Condominium. Very briefly, I will largely rest on the papers. As the Court is aware, the $6,000 fines that are the crux of appellant's failure to pay her common charges for the past 5 years have been waived. That notwithstanding, the appellant owes over $160,000 at this point. And she's alleging that basically she cannot pay money until the end of this litigation, at which point, given the series of motion practice pre-answer and the course of appeals before this matter has even really moved anywhere, could be years. So plaintiff is basically, appellant is largely saying that she can live for free because the condominium may or may not have misapplied some of her funds to $6,000, which they now waive. Appellant has no defense to her failure to pay common charges. Under RPL 339J and under Frisch versus Bellmark and other case law, the obligation to pay common charges is absolute. And if plaintiff disputes as appellant disputes the common charges, the proper method for her to deal with that dispute is to pay them and then seek an abatement. However, ceasing to pay common charges completely is indefensible by any of the defenses put forth by appellant in this action. So if there are no further questions.
And how would she seek an abatement? If she believes that she shouldn't pay all of that money, what you're saying is she should pay the money under protest, and then how would she seek the abatement?
She could commence litigation. Appellant is an attorney. Appellant is versed on how to seek an abatement, but she's obligated as an owner of a condominium unit to pay her common charges. She can't live there rent-free because she disputes $6,000 that have now been waived.
That's what you were talking about. You were talking about an abatement of the $6,000.
Correct.
Right. So you're saying that she could have paid the $6,000 and sought an abatement, or she could pay the $6,000 now. Well, you're waiving it, right?
We're waiving it. To clarify, I was talking about an abatement of her common charges. If she's disputing
You
her,
just want to be paid the outstanding common charges with
correct,
interest.
the $100-something
$100,000.
thousand that the condominium needs to pay for its staff salaries and its lighting and everything, and that other unit owners are now forced to make up for because, as appellant admitted, does not believe that she has an obligation to pay anything until the conclusion of this litigation, which has already gone on for several years.
Thank you.
It should be noted that I made an offer way before this action was commenced, right maybe a month after the misapplication, to settle this case as long as they waived the $6,000 fines and they recredited the May 2018 common charge payment back to the month to May 2018, and they declined.
Is that still your offer? Is that offer still on the table? No.
I would
No,
consider
I think you guys, I think you should discuss it. I'm curious, what affirmative defenses would you be waiving by actually paying the common charges?
Well, that's the law of the First Circuit, that if I...
No, which affirmative defenses? Give me one affirmative defense that you would be
There's
waiving.
17. There's illegality based upon the implementation of House Rule 43 as well as the $6,000 fines, that they did not have the legal right to do so. And so, perhaps there's retaliation. That's another affirmative defense. There are 17 I listed.
No, I understand. I didn't know which ones would be applicable to this particular case. That was my question.
So all of my affirmative defenses would have been wiped out, not just that $6,000 amount. There are two issues that I would like to raise before my time runs out. One, there is a motion that I filed, served and filed this past Thursday, October 12th, that is returnable on the 30th. I respectfully request that if the court determines these appeals prior to that time, that the court retains jurisdiction to hear and determine that motion. In addition, there is a motion for sanctions that has been fully briefed and submitted on the papers in the lower court. I respectfully request that if the court reverses the denial of the motion to dismiss and grants the motion, that the lower court be permitted to retain jurisdiction in order to issue a decision on the motion for sanctions.
Thank you. I suggest that you put the offer back on the table and consider settling the matter. Thank you.